Good morning, everybody, and welcome to the second day of the International Conference, Can Justice Be Child-Friendly? European and National Perspectives for a Multidisciplinary Approach Towards Unaccompanied Children. Today, we have the pleasure to have two sessions that in a while we'll see in detail what's going to be discussed during the next hours. And we would like to thank all the panelists who gave us the pleasure today to bring their contribution in the topics concerning the Child-Friendly Justice Project, the project under which this conference was organized, a project funded by the European Union under the Rights, Citizenship and Equality and Citizenship Programme. We would like to thank all the participants who already are with us, and we hope that soon there will be a really wide audience. And we would like to give the welcome, even to thank all the interpreters and the technicians for the support they are providing us for a successful result of the event. Well, about in detail what we are going to discuss today, let me show you briefly the agenda before going to the details of the topic. So, as you can see in the agenda today, we will have a first session where we will be covering the challenges from an international and national, from either the international and the national perspectives, challenges faced by unaccompanied children, victims or suspects or accused of crime. We will have three interventions during the session that we'll see in detail when introducing each panelist. After each session, we'll have a Q&A moment, a moment where all the participants can just raise up their hands to ask questions, or they can just write a question in the chat, and we'll have the opportunity to use this virtual space to answer the questions, but even to make reflections, considerations, or any further requests. And in the second part of the morning, we'll have some experts of the partnership of this project that will be presenting that EU models that have been developed in Italy, in Bulgaria, and in Romania for a more inclusive and child-friendly courts. And this session will be kind of different from the first one, as there will be also an interactive part with the audience. We'll be proposing a survey just to even provoke and to give inputs for further discussion. Also, as in the previous session, for any further question or clarification, there will be a final moment in case to exchange feedback and opinion. Just to inform you, this conference will be recorded. So as far as you filled up the registration form, we were asking for your consent to record also the conference. And going to the detail of today's session, let me just make some consideration to guide you to have to have all the framework clear in following this conference. As far as we are going to discuss today, we would like to just clarify a few things. We'll be first focused in a critical way on the legal and social implications faced by unaccompanied foreign children in the Italian criminal justice system, but also on the challenges emerged towards unaccompanied children involved in the criminal justice system under another project funded by the REC program, the CRU project. As a solution to overcome those challenges, it will be highlighted the importance of a multidisciplinary approach for the child's best interest as adopted in the EU models from Italy, Bulgaria, and Romania. These models of individual assessment were created based on the result of the research on the theory, policies, and existing judicial practices identified from our partner countries in Italy, Bulgaria, and Romania. For what concerns the Italian fieldwork, we would like to thank all the professionals and young adults who we interviewed and who shared with us their experiences and who make clear points of strength, but even points of weaknesses of our system. As mentioned yesterday, is more than valuable. The contribution brought from the three actors we selected as successful multi-stakeholder cooperation experiences. The USM, the social service experience, the CLEDU, the legal clinic, and the multidisciplinary approach proposed by the teamwork of Catania. We are pleased to share with you some findings of the Italian research that were trying to give an answer to the question, to what extent are unaccompanied children rights granted within the Italian legislation with reference to the EU directives number 29 of 2012 and 800 of 2016. Concerning the Italian framework applied towards unaccompanied children, there is an intersection of legislation. We have to have in mind that there is an intersection of legislations in the area of asylum and international protections, human trafficking, and other crimes. We found out that it's relevant the adoption of a legislative framework, the so-called Zampa law, the law number 47 of 2017, that is the first European comprehensive framework for unaccompanied children. At the same time, this law is pretty relevant for the recognition of some specific vulnerabilities of children for the same protection ensured not only to national children, but even to foreign children, for the provision of new institutional figures, such as, for example, voluntary guardians, or even to the figure of the cultural mediator. These are some considerations related to the legal framework, but in going into the detail of one of the most relevant topic of our project, the individual assessment procedure, we found out that the Italian system has different features. First of all, we have a proliferation of actors in name of a multi-stakeholder coordination. Then we could make even some consideration about how this multi-stakeholder approach is actually working, and what has to be recognized as properly done and what can be improved. Second of all, we found out that the proceeding seems to be child-oriented, as there is a capacity of the multidisciplinary team to choose freely whether and when to hear the children. Well, in some cases there are the conditions to do so, in other cases not really, unfortunately. Then about the nature of the information provided, found out that normally it's provided a cognitive, we can sum it up as a cognitive information, ensuring that every person involved in a proceeding understands the language and the judicial context. This is something really important to avoid and to reduce the implication coming, the risk coming from some judicial path that are not based on a proper and cognitive information. We would like to underline as well the important, we would like to underline it based even on the results we found out in our research, the importance of the cultural mediation in terms of increasing what we were saying before, an aware recognition of the children's rights, but even a better communication in terms of language, but even in terms of understanding in a mutual way the context where the child comes from, but also where the context where the child arrives. In terms of participation of the child, we found out that the participation of the child upon proceedings seems to be protective as far as for what concerns the action of the actors that are actually facilitating the child participation. And for what concerns the general legislation applicable for the individual assessment process, we found out that there are law provisions that regulates the individual assessment process, but unfortunately there are no standard regulation of the individual assessment, as is a procedure that is regulated and that is actually addressed on a case-by-case way. These are some findings of the Italian research that are kind of addressing the Italian model that will be later presented by our child expert. We will have the pleasure next week to receive some presentation about the Bulgarian and the Romanian models. Also, our partners will later present the outcomes of the research findings during the session 2. For those who are interested in the research findings, we'll in a while share with you also in the chat a link with the reports from the 3 partner countries. So let me briefly now give the welcome to the panelists of the session 1. And first of all, let me give the welcome to Mr. Pippo Costella, the Director of Defense for Children International Italy, International Social Service, that is going to make an intervention with the title Unaccompanied Children and Justice, Perspectives on a Critical Relation. Thank you, everybody, and enjoy day-to-day events. The floor is yours, Pippo.
Thank you very much, Antinea. I'm going to talk to speak in Italian, since I would like also to concentrate on the Italian situation. Andrò a parlare in italiano appunto perché mi vorrei concentrare.
Actually, I will speak Italian because I would like to focus on the Italian situation, which is also symbolic, also regarding some principles and some regulations that have also an international impact. First of all, I would like to thank you for this opportunity, which I think is very important. I think that it's very important that we have this webinar organized in Sicily, where we have the project leader. And actually in Italy, in Sicily in particular, there are some major events taking place. There are also some contradictions when we talk about justice and justice for unaccompanied foreign children. So going back to what was discussed and debated yesterday, I think there are some aspects that make it clear that it is quite difficult to talk about the child-friendly justice within a context where there are lots of shortcomings, dysfunctions, also I would say structural discrimination against sorry, my telephone keeps ringing. I have to silence it. So I was saying a structural discrimination against young people coming from other countries outside the European Union. So it's difficult to talk about justice without considering the context where foreign children are accepted and welcome, and how much this is in line with the principles and with the rules that should somehow govern the relationship between the system, the judicial system, and children. I think there is some convergence between what we can analyze about the number of foreign children in Italy and Europe as a whole, and all the issues concerning justice itself. I think we need to talk about this sort of convergence, and actually from the second session yesterday, this was made quite clear. That is to say, justice measures are somehow a sort of last resort. The answers are provided to issues, to problems that should be examined even outside the court system. So we have to have this convergence, and we have two areas where we work, one concerning foreign children, and then we have the justice system on the other side. So in this way, we have to point to the necessary integration. And this has to be done by joining together these two areas. So without looking at the context, without looking at the root causes, I think we cannot actually talk about proceedings, juvenile criminal proceedings, and children that have to that are subject to this youth justice system. Unfortunately, there is this gap between these two areas, and there is a big gap between regulations and facts, actual situation. I won't delve on the existing legislation now. The only thing I want to do is that what is written on paper is only partially applied. And if it is applied, it is done so in a fragmentary way. And obviously, this doesn't help in preventing, for example, crimes, etc. If we do not deal with this sort of connection, I would say it is impossible to have a more virtual analysis where we look at the principles, we examine the principles, also the same principles should be translated into practice, which is not always the case. So yesterday we were talking about individual assessment as one of the focal points in our conference. And interestingly, I think we would have to have a sort of general assessment, not individual assessment, a general assessment, a collective assessment, because without it, we won't be able to apply those principles that are necessary for an individual assessment for the individual child, and that help us identify the individual features of each child, of each history behind a child. So we need a sort of more system-based approach, integrated approach to actually answer to this very difficult question raised by this webinar, that is, can justice be child-friendly? So this big question mark, I think, is also the core of what all our analysis should be. Yesterday, we discussed about children who are victims or offenders. In both cases, we talk about children in a condition of vulnerability. Actually, one of the early or the first speakers spoke about human trafficking, and obviously this issue of human trafficking has to be dealt with in terms from a criminal point of view, but there is some sort of reluctancy around this topic. That is to say, human exploitation and trafficking actually on an international level, they are linked to circumstances and contexts that produce vulnerability. For example, I would say that today it is still very difficult to consider human trafficking and exploitation as integrated processes and consequences of the system which is producing vulnerability. And I would say that there are also criminal responsibilities as to the violation of human rights of individuals, but there are also responsibilities, shortcomings leading to this type of exploitation.
Di reato, le vittime di reato, come il prodotto che genera.
We might think of this as a context that generates vulnerability, the context that promotes the concept of justice. So you can imagine the type of contradiction that we have, a situation in which the whole justice system, the institutions proposing the concept of justice are the same institutions that, due to omissions, due to mismanagement, or due to particular interests, I'm referring to organizations that should be participating in the response to the problem, but they operate in a closed manner and they belong to the problem. So this context generates vulnerability and a phenomena of exploitation, abuse, violation. So I propose this analysis. I widen the horizon, but I propose to start thinking of this context, of the analysis of this context as the way to find an answer to this issue, to this question coming from our meeting. And having said this, in addition to the details that will be stressed in next presentations, I would like to refer to three particular dimensions. They are general, but they are particular. First of all, the Convention on the Child Rights of the United Nations, ratified in 1991 in Italy. It is our law. So we talk about the best interest of the child. So we must consider how and how much this convention can be an instrument of orientation for practices, policies, and strategies. In our DNA, we have this convention within our organization, but this convention is not known, is not applied, and it is not considered as a primary reference in the analysis and in the action. So the first proposal in terms of convergence between the theory and practice is to say, if we want to talk about justice, we have to manage to qualify this convention that must be a primary instrument of analysis, not only for jurists, a general reference for all of us, because we all agree with the rights of a child and adolescents. It must be a working instrument in order to analyze a context and to analyze what the context means for a person. So there must be a comprehension. There must be the implementation, not only in juridical terms. I remember that the convention is multidisciplinary, created by jurists and by experts in psychosocial subjects, pedagogists. So this convention is rich in meanings that are not used yet. So how much is this convention used? For example, a reception center or the justice system. How much can this instrument be used in terms of principles and regulations proposed by this convention? And so I invite you to consider this convention as an underused instrument. This convention dates back to 1989. We are in 2021, and only a few people know and use this convention as a reference instrument in determining analysis and practices. The second reference that was mentioned yesterday is 448, dating to 1988, a year before the International Convention on the Child's Rights. So our system developed a philosophy and an approach to child justice that was innovative. It is still innovative. It had a specific vocation in dealing with the subject, but it was not specialistic, because it considered what before and after justice system was for that child. So it proposed a pedagogical vision in line with this idea proposed by the international legislation in its articulated expression of the subject matter. Some conventions were mentioned yesterday. 448, therefore, as a capital that is present in our country, that reflects the principles and standards of the convention, but unfortunately, it is underused from the point of view of the relation. Yesterday, the ladies of USM said that this lack of connection between the justice system and what is around, before and after. So if the general reference can be the convention on one side, but on the other side, we have a legislative capital translated into the 448. We talked about individual assessment in an emancipated manner as compared to other systems of other countries. Our legislation and our regulations concerning children was summarized in the specific aspects of foreign unaccompanied children, and there was the law 47 of 2017, and the article 1 says that any foreign child has the right to the same opportunities as Italian children. So there are no differences in our system between the guarantees for a foreign unaccompanied child and a national child. So there is a series of principles put together in this law, translated into accurate, precise indications, practical indications, starting from the connection of our legislation with the international principle. The Article 1 connects this specific law on foreign accompanied children to the corpus of orientations coming from the international legislation. The comprehension and the application and the integration of these three instruments can give an important orientation in terms of response to this issue. The justice can be child-friendly. The divergence between theory and practice can give a response. I would like to share with you a map that we are making. We observe a law 47 in different Italian territories, and we tried to translate into more comprehensible and direct indicators the various points of the law. I think that it is interesting to share with you this type of map because we realize that Law 47 proposes a series of elements that are relevant and important in order to prevent any violations and not to make a foreign child a victim, and to make him or her, to place him or her in a position not in conflict with the system. So this law, if it is meant this manner in the relation between the various specific aspects, can be very useful, I think, to allow us to understand something concerning the issue of today's webinar. I will not detail the particulars, but I invite you to consider the implications of each element in determining a more balanced and credible condition as to the concept of justice for foreign unaccompanied children. We talk about qualified reception, and we know that it is not qualified in our country in quantitative and qualitative terms for foreign unaccompanied children. There are some virtuous situations, but there is a disproportion between the presence of children and the conditions that make this reception qualified. Considering the distribution of foreign children on the national territory, we see that there is a disproportion between the numbers of children received in Sicily and the others received in the rest of the country. I'm referring to competencies within the facilities, connections between the facilities and the institutions and the reception centers. And I'm referring to the possibility for a child to find a context that can cope with his or her conditions. I always remember Article 1 of the law. There must not be a parallel system as compared to the system of Italian children. The quality of receipt is a problem. In many cases, it is not qualified reception. And you can understand what this can cause in terms of vulnerability and the conflict of children with a system that says that it receives, but it receives badly, actually, in a situation of emergency. And the foreign children in Italy are an historical phenomenon. So the issue of guardians, Law 47 envisages a voluntary guardian for every foreign child. This profile is very much at risk at this moment in time, because very often there is no guardian. In most cases, there is no guardian. And some institutions act as guardians that cannot give the right, cannot have the right care that each child should deserve. There is a problem of training. There is a problem of presence, of clearness in terms of these institutions, and the national organizations have problems in qualifying this profile. That is very important. So you can understand the difference for a child to have a person who devotes a part of his or her time to support his or her difficult life path. So this is a chronic deficiency of the system. And so the institutions are very weak in terms of training. Yesterday, the lawyer who talked said that it is necessary to specialize these profiles, but guardians are no micro professionals, but they need to be trained and supported. So the institutions must be responsible. I'm referring to data sharing, for example, so the social files, the documentation concerning a child is very weak. The different institutions do not coordinate in terms of data. So this phenomenon is blurred. And there are situations, therefore, of vulnerability and of conflict for a child in a system where the child is not recognized in terms of right. I'm sorry. I'm sorry, but I'm asking you to come to the end, to the conclusions. So, listening procedures, the identification interview, the assessment of the age, the relations between our institutions and the family of origin. And then the majority, and that is really a big, great problem for children. How can we think of a system of justice that does not consider the coherence of our analysis of our action in terms of what the law envisages? So, will it be possible to talk about a type of justice that is a friend of children in a context in which this justice is system, policy, and jurisdiction? When we recognize that this system is not suitable, so we will deal with the individual evaluation. And I think that this is a path, a precise path to generate the credibility and the sustainability of a justice proposal. for foreign children. And to conclude, I come back to the convention talking about the best interest of the child and about three other main principles: the maximum guarantee in terms of possibilities of development of that child. Two, the issue of non-discrimination. We know that, as already said, foreign children are still discriminated on our territory. In terms of what the law envisages, because the law says a treatment of equal opportunities. And so, due to a vulnerability that quite often is determined by the system. And the third principle, the participation. So there is this issue of the invisibility. Invisibility that is shown in very forms, present in various forms, in which the context of being an offender or a victim. So all this is shown in a strong manner. So when we talk about the best interest of the child, we must have clearer references in terms of national standards, not only in juridical, in legal terms. We have to apply a paradigm that can be credible for these children. So there is a problem of continuity of our analysis made of knowledge, of practices. I have concentrated on critical elements. I know the efforts of the operators working in this system, of the professionals working in this system, but I'm trying to show you a basket of elements, and this is a complex logics, but it is necessary to deal with the issue of this webinar. Thank you very much, and sorry if I have been so long.
And inspiring intervention. And now, just before giving the floor to the next panelist, let me remind to all the participants who joined the conference even later that there is a possibility to use the interpretation. You will find in the bottom side of the Zoom a kind of words icon, and you can just then switch there from English to Italian or from Italian to English. And just to inform you also that this session, this conference has been recorded. So we hope that you don't have any issue with that. Many thanks to Mr. Costella for the event. And now I'll give the floor to Alberto Pasquero, a lawyer researcher in the field of international criminal law, that is going to make an intervention named Risks Faced by Unaccompanied Children in the Italian Criminal Justice System. The floor is yours, Alberto.
Thank you.
So, thank you so much.
Thank you for the invitation. My name is Alberto. I'm a lawyer. I work in a law firm based in Torino, Italy. We work almost exclusively with foreign citizens, asylum seekers, and foreign citizens in general. I have to say quite a lot of these clients that we assist mostly through publicly funded projects are minors, are unaccompanied minors who arrive on the Italian territory, and some of them also have problems with the law, criminal law. And so this is the point where my work experience, which is a very practitioner's experience that I want to bring to the table this morning. You know, this is the moment when my experience crisscrosses with the topics that we we are discussing this morning. And my presentation will largely echo what Pippo just said in much more eloquently than I will. And I will try to give a practitioner's angle to put into practice a lot of the principles and of the critical aspects that Pippo has already mentioned in his presentation just a minute ago. And I will try to do this by going over together with you a personal story of, it's a true story of a client of mine who arrived in Italy when he was a minor, and we will go through this story in a second. And I will try to highlight what I believe are the more critical points in this person's story. His name is Khalid, it's a fictional name. And at the end of this presentation, you will tell me if the Italian justice system has been child-friendly towards this unaccompanied minor or not. So let me just share a few slides that I will use. So let me introduce you to Khalid. It's a fictional name, it's a fictional photo, of course. Short background to Khalid. So he's 17-year-old when he arrives in Italy. He's from Egypt. From rural Egypt. It's an area with widespread violence, especially towards his community. He's a Christian. In his area, there are Islamist fundamentalists who are very active and they target Christians. More generally, in his area, violence is quite widespread. Lots of firearms, family disputes that often end up in, using weapons and stuff. He comes from a relatively poor family. He was a bartender serving tea in his cousin's tea shop. That's what Khalid did in Egypt, very little education. So this is his background. Maybe he was even a troublemaker back home. We don't know, but he was certainly afraid of serving in the army. So the moment of the call of duty was approaching, and his family decides that it's best for Khalid to leave and to find hopefully better opportunities, maybe even more education and a more decent job in Europe. And this is how he sets off. They pay a smuggler and they put him on a boat and he arrives in Italy after a perilous journey. So this is the first chapter of Khalid's story, arrival in Italy. So let's see how the, and again, you will find a lot of what I'm saying is just a practical application of what Pippo just said a minute ago. And so let's see how the Italian system received a minor like Khalid. Well, first of all, he arrived in Sardinia on an island in Italy, and that's not where he wanted to go. He wanted to go to Milan, where his family told him there's a cousin. So he leaves the reception center in Sardinia. He goes to Milan, and only to find out that his cousin is not so eager to host him. He has his life, a family, he has his job, and he doesn't have a room to spare for Khalid. So that's where Khalid starts being on his own, and he tries to get into a reception center for minors, just an overnight facility, except they have no place for him. They fail to alert social services. A legal guardian is never appointed for him. What does Khalid do? Well, he resorts to his own community. He finds other people from Northern Africa, Egyptians, Moroccans, who are living on the street. Of course, he has no residence permit, no permit of stay. As you most likely know, all minor Minors in Italy cannot be expelled, so they are automatically entitled to a residence permit. But of course, the system needs to take care of that for you. Otherwise, you will never know how to get it as an unaccompanied minor. So Khalid has no residence permit. He finds himself, as I said, wandering around the streets with fellow nationals. He has no money. So these people, they need to find something to eat. Frankly speaking, they also try to find something to smoke. And this is how they make a living. They are out on the street on their own, a bunch of kids. This is an important point that I want to make because there's always a part of, let's call it cultural clash, to be a bit explicit. We could say it more, I'm sure people would know how to say this more subtly, but there is, and this is where he was mentioning not only the individual assessment, but also the generalized assessment on foreign minors. There is a lack of knowledge and a lack of awareness to some extent. I mean, they know that killing somebody is illegal, of course, but to a more subtle degree, foreigners, when they arrive in Italy, they're not fully aware of what the exact Italian laws say, what kind of behavior is not tolerated, what is tolerated, what is appropriate, not appropriate, acceptable, not acceptable, but notably what is criminally relevant and what is not, because of course all people who are on the territory, they are presumed to know criminal law, even if you don't know that something is a crime. Well, that's no excuse. We all know that from our criminal law studies. But this is a principle that is not absolute. And you can always prove that you did not, there was no way for you to know that this was criminal. And again, you know, this is a fine line. This is a fine line, but I can assure you that that some behavior that some communities of foreigners, especially minors, engage in Italy, I'm pretty sure that they don't know that it's so bad, or that that some criminal act could end up in long prison sentences, such as like 5 years of imprisonment. I was on a train, just on some anecdotal experience. I was on a train just very recently, on a night train from Milano to Torino. And I was in a cart which was full of North African kids. And these people, they were so they were so aggressive towards each other, and they were kidding. You could tell that they were kidding, but their way of goofing around as teenagers do was so violent to our eyes. They were, slapping each other, punching each other, flying kicks, kung fu almost kind of moves. And as long as everybody's fine with it, I guess it's fine. But sometimes the game can go a bit, it can become a bit too violent, and somebody might decide that they've had enough and they can start threatening you or report you to the police. And sometimes they do. And I have another client right now who is in jail for something like that. I'm not being apologetic towards violence, but I'm just saying that sometimes there is a need to make an assessment of the background that some people come from, and their way of goofing around might be a bit different from the way of goofing around that Italian kids are used to. This client was saying, but come on, why am I in jail? This guy, the victim, referring to the victim, this guy, he's a fellow citizen, he's a fellow Egyptian guy. And I was like, but that's no excuse. I mean, you cannot beat up an Italian guy, you cannot beat up an Egyptian guy, but in his eyes, he did nothing wrong. It was just a brawl among friends, except it ended up in robbery charges, which are extremely serious charges under Italian laws. So again, the violent background, the country of origin, and the social laws, what is accepted, not accepted, might vary a lot. And so I think these cultural differences, they do need to be taken into account when and making the individual assessment of the child's position that was repeatedly mentioned. So this is the crimes that he ended up being charged with. I mean, in this case, it was more clear cut. You know, they were stealing cell phones from other teenagers or robbing them, depending on the exact modes of commission. So Khalid ends up being arrested. So let's come to chapter 2. Khalid gets arrested. So what happens? Let's see how the system treated him. Of course, Khalid knows no lawyer in Italy. They appoint an ex officio lawyer for him. He gets also paid by the state through free legal aid because Khalid has no money. So that part works, except well, it's very hard for an Italian lawyer to be able to communicate in Arabic with his or her clients. So there's definitely a language barrier. How do you prepare a defense if your client is not able to tell you what happened? So definitely the quality of the defense that you end up getting as a foreigner in general, and especially as a minor, as an unaccompanied minor, is clearly worse quality than you would get if you are an Italian kid whose family maybe is friends with a lawyer or can afford, you know, a lawyer who's good at criminal law, etc., who is experienced. So you might get a very good ex officio lawyer, but it depends. It's a bit of a gamble. And definitely for everyone, there's a big language barrier. What about trial? The Italian criminal procedure code for minors foresees, for example, the presence of family members. They can be there. He's an unaccompanied minor, so no family there that can give him moral, support. The lawyer ends up entering a guilty plea. So they fail to make use of one of the key mechanisms in juvenile criminal proceedings in Italy, which is juvenile probation, messa alla prova. It's something that now exists also in criminal proceedings against adults, because it works pretty well. The goal of juvenile criminal proceedings is not to repress through putting people in jail, putting minors in jail, is to give people another chance to think about their mistakes, realize they've done something wrong, do something useful for the community, compensate the damage that you created, and reintegrate you into society as soon as possible. Correct the mistakes you might have received or mistakes that the gaps that there might have been in your upbringing and education. This is the idea. Of course, this is not going to happen if you enter a guilty plea and you end up in jail. The judgment becomes immediately final. There's no provisional release. There's no detention on remand, which would happen if you are tried. There's a first instance trial, then there's an appeal. Maybe while the proceedings are going on, you might get a provisional release because the judgment is not final and you cannot be kept in detention or remand forever. But this is not what happened in Khalid's case. The judgment became final, so no provisional release. He got 3 years and 4 months of imprisonment. The fact that the judgment becomes final also creates a major obstacle in obtaining a future permit of stay, because if you're a convicted offender, Italian law foresees impediments to your possibility of getting a permit of stay also as an adult. This is a stain on your criminal record that is going to stay there, unfortunately, for a very long time, until you are able to access rehabilitation and delete the consequences of the criminal conviction. So what follows arrest and trial? might have guessed it, there is juvenile detention. So chapter 3 in Khalid's story is detention. What happens in detention? Well, detention is an integral part of the juvenile justice system, isn't it? It's the way that you serve your sentence. And so that part of the system also needs to be child friendly, especially towards foreign unaccompanied minors, and God knows how many of them there are in Italian jails for the reasons that we will mention in a second. There's, you know, the percentage of foreigners that are in Italian detention centers and prisons is, you know, far outnumbers the percentage of foreigners that are out there in real life, so that there's many more in jail in percentage than there are in the free world. So what happens to a kid like Khalid, a 17-year-old? He speaks no Italian at all. He has somehow fails to understand why it's so bad what he did, and he ends up being detained. He does not understand why he's in jail. He still thinks that it's a big injustice perpetrated against him. He does not realize the gravity of what he did, which is serious. I'm not saying the opposite, according to the Italian criminal code, but he does not understand it. And that's a big problem because he does not accept the fact that he's confined between four walls, that there's prison guards around him, that there's other kids who's, you know, with dodgy faces and dodgy behaviors. So the reaction of a teenager is rebellion. He doesn't want to be there. He kicks around and he punches around walls, and he's even at some point he tries to escape, and the prison guards tell him, "Oh, you want to escape? That's the wall. Try and climb it. Go!" And he's like, "Okay, I'll give it a try." You know, he doesn't even understand that it's so. That it's. I'm saying it's a joke, but it was a provocation by a guard who said, "Yeah, this is the wall. Climb it." So he tries to climb it, and they charge him with attempted escape. So more crimes. He ends up being being restrained by security guards, and he kicks around, and he gets another charge for resisting the public authorities. So this is how the system risks becoming even criminogenic towards people like Khalid. There's a huge language barrier with prison guards as well. They don't speak Arabic, and he doesn't speak Italian. So how are they going to understand each other? Where occasionally there's a cultural mediator in prison, a very nice Moroccan lady who comes like 2 mornings a week. She speaks with, she has some meetings with the inmates. She explains some things, but again, she's there like 2 mornings a week. So what about the other 12 mornings and afternoons in the week? There's no cultural mediator. Everything is left to a sort of prison slang, prison Creole language, a mix of Arabic and Italian, gestures, body language, and yelling. And that's the language of the prison when you don't speak the language. So there's inevitably, you're going to incur disciplinary offenses. They tell you, get out, face the wall, do this, give me that. You don't understand. People start yelling at you, and this is how the system again becomes criminogenic. You get disciplinary offenses, you don't get early release benefits. All right, so everything is much more difficult, even for what might seem a silly problem like language problem, but it ends up being a huge problem. And then there's also the support. We all know how important family support is to kids. If you're an Italian kid, you might get visits by family or friends, but if you're an Egyptian 17-year older, you don't have no family, you don't have friends, you don't have anyone who can come and pay you a visit or bring you cigarettes or some orange juice. On top of that, the family, in this case, and I'm sure that it's a very common story, the family puts a lot of pressure on these kids. They paid a lot of money to make them escape to Europe. They want to, I mean, the worst case, they want to see a return on their investment. They expect these kids to start paying back and sending remittances back home. In this case, they were extremely disappointed, to say the least, that Khalid, instead of making pizzas in his cousin's shop, he was, in jail. So they call him a failure. They call him a disgrace for the family. They blame him that the mother fell ill because of that. And Khalid goes down. He becomes depressed. He becomes very anxious. He has a sense of failure. He sees no hope. 3 years is an extremely long time horizon when you are 17. So 3 years in jail. There's a moment when he attempts suicide after a phone call with his family. They find him with a bed sheet tied around his neck, hanging from a bed. It's a bit of a goofy attempt. They managed to rescue him. They sent him to the hospital. Maybe he wouldn't have succeeded, but that's not the point. The point is that this kid was completely lost. He had no perspective in his life at that point. And again, who is there to help him, to lend him a helping hand? Well, luckily he ran into a very caring social worker, and that's also where I came into play in Khalid's story. They realized that, for example, not having a permit of stay was a major concern in his mind. So we managed to apply for international protection from inside the jail, which is not very often the case. There's a lot of barriers in accessing permits of stay from inside the jail, very simply because you cannot go to the police to apply and give your fingerprints. You are in jail, you're restrained. It's very difficult to access that kind of procedure. Somehow it's possible, but you do need to be surrounded by people who care. And this is not always the case. But anyway, in this very dark moment in Khalid's story, he enters, he does find a social worker who takes some care of him, and somehow they want to try and do something about him.
Alberto?
Yeah.
Scusami, possiamo avviarci verso le conclusioni?
Certamente.
Grazie.
This is my just a couple more minutes. So what about alternatives to detention? This is another problem for foreign kids. There's if you don't have, imagine you want to apply for house detention. Well, you need to have a house to be placed. If you have no family or friends in the outside world, it's very hard to apply for these kind of alternative measures. It might seem a very practical obstacle, but it's a huge one. An Italian kid would apply for house detention at his parents' place. Well, this is not the case for unaccompanied kids. I already mentioned that social services are overworked and underfunded. There's very few people who care. So it's difficult to draft probation projects. There's no funds for these kind of housing, labor projects. Well, in theory, they exist, but at the end of the day, who's going to do it for you if they have no funds and no spaces to send you to live and to work? And I just want to mention a last chapter in this story. I already mentioned the difficulties in obtaining a permit of stay from inside the prison, but this is a crucial part of in the release phase and the reintegration in society, which is the ultimate goal in all well, generally in the detention system, but even more so in the juvenile justice system. If you don't have a permit of stay when you are out, well, it's a big problem. You cannot get an ID. You cannot get a work contract or a housing contract. If you have you don't look too Italian. It's sad to say, but you're incredibly more likely to run into police checks. In fact, I never ran into a police check in my life, and these North African kids or African kids or anyone who doesn't look Caucasian white in Italy is very likely to be checked by the police. And if you don't have a permit of stay, well, they might hold you, put you in police holding cells, and that's where the system again becomes criminogenic. But there are some opportunities for juvenile offenders, and I'm coming really to the end of my presentation. What are these opportunities? I want to mention especially one. There's Article 18, paragraph 6 of the Italian immigration law. It's a special permit. It belongs to the family of social protection permits, and it's a special permit for juvenile offenders who, they have been detained as minors, and if they participated in a social reintegration program, they gave proof of being on the right path, so to speak, and they were part of a rehabilitation program. They can be granted this permit. There needs to be a favorable opinion by the prosecutor, the judge. But at the end of the day, if you're followed by juvenile social services and your behavior was good, it's not so hard to get it. And it is a big opportunity for people who, in Khalid's case, he got asylum or something that resembles asylum, but because of his criminal presence, he couldn't get refugee status, but he did get a permit of stay. We call it special protection. But a lot of other kids, they cannot get asylum. They don't come from persecution contexts. So what kind of permit of stay are they going to get? They go out of jail. They are already over 18. They cannot get a permit for children. It is an issue. So this Article 8, paragraph 6 might be the best chance for juvenile offenders upon release. And I'm going to stop there because I'm way out of time. Thank you for your attention, and I'm available for any question or comment afterwards during the discussion. Thank you.
Thank you, Alberto, for your story, for the story that you shared. It was really, really, really interesting. And actually, this story, together also with the inputs that Mr. Costello was giving in the previous sessions, are kind of, in certain aspects, are in harmony with what was even discussed yesterday, even about some gaps of the system, even about some challenges that are faced by professionals of different sectors, by legal professionals, but even by social professionals. I mean, that's the sense of working effectively in a multidisciplinary team, because if there would be a good if there would be harmony between all the actors involved that are asked to provide a certain contribution for just to follow the child in all the steps, in all the phases of the proceedings, probably there would be less injustice in this sense. So really, thank you so much for this story. And for any comments, any questions, any consideration, we'll just remember you that we'll have some space after the next panelist. And now I have the pleasure to give the floor to Sebastiano Vinci, who is the head psychologist of the ASP Palermo, the Department for the Treatment of Unaccompanied within the Department for the Treatment of Unaccompanied Children, Victims of Abuse and Violence. It will make some consideration. His intervention is going to focus on the psychological implications and risks faced by unaccompanied foreign children, victims of crime involved in individual assessment procedures. Welcome, Sebastiano, and the floor is yours.
Grazie, buongiorno a tutti.
Thank you. Good morning, everyone. I thank you for inviting me and for having this opportunity to speak in this conference. My presentation relates to what has already been said by Mr. Costello and Mr. Pasquera, but with a specific approach as a psychologist working for a public facility concerned with foreign unaccompanied children. We stipulated a memorandum of agreement with Doctors with No Frontiers for victims of crimes and tortures and of violence. So I will reflect on these on this issue. I will make some observations on this issue, and then I will talk from a psychological point of view. I gave a title, Time for Migration and Time for Justice. This is the title of my presentation. I think that when we deepen the issues concerning the relation between justice and the foreign unaccompanied children, we have to consider the time of the migration paths of people coming from other worlds. And this time aspect is within the historical moment that concerned the immigration flows from Tasmania in search of assets and from the entry of migrants into Western countries, lands of illusions after the horrors written on the body of everyone. So we consider this time and we can understand what children, boys and girls coming from other worlds pushed the boys and girls to leave their own country and their affections did not prevent them from leaving the country. There is nobody, there is nothing to keep them in their countries. Colonial policies gave no power to social structures, and there are no symbolic links of populations with respect of rules, their internal systems, the recognition of their authority within a social context in which they were recognized. The virtual world gave some illusion images through the internet, and so they shared some different cultures, some different livings, far from their customs and habits. So the exchange of information through videos, texts, images did not have rivals in terms of the traditional message concerning the symbolic systems of a population. And so in this respect, that there is no tradition, there is no people's culture, because the colonial policies created violence, and there are religions and cultures that do not belong to dominated populations. Gabizza in Arabic means the expedition of army, the incursion in an enemy country in order to devastate animals and people. So this word and I wanted to share with you the root, is strictly linked to Nazism. That is to say, the concept based on the principle of a superior human race. And against the genocide. And so there is the absolute predominance of a superior race. So these terms of race and racism allow us to include their use in the legislation, because in certain states the legislation is against racism and the racial laws, for example, the apartheid. The history of United States of America showed this in the past and still today. Racism, a complex set of manifestations, intolerances expressed through form of marginalization and scorn towards groups belonging to different ethnic minorities is hidden in legislation, in law articles, but also in the intellectual convictions within anti-racist laws promulgated in most states. Starting from the 1940s, UNESCO allowed to create a movement in order to cancel all these race prejudices. Thanks to the Declaration of the Man, Article 2 recognizes the freedoms without any distinction of race, color, sex, religion, language, or political opinion. So this principle was recovered, as already said by Mr. Costella, by the European Convention of the Human Rights in 1950 and the Convention of 1966 and the European Constitution at the end of 2004. So migrants or minor migrants or adult migrants who escape their country because of extreme poverty conditions or because of ethnic wars that cannot be managed by any social system. So these migrants cope with an Italian legislation system that ensures guarantees, because there are the rights of the child according to the convention transposed into Italy, but very often they have bureaucratic difficulties and they see the traumatic scenarios that they lived. And so they have these in their memory and they altered the vision of their life. So before the territorial commissions for the recognition of the international protection, those who give their witnesses, they have a double aspect. That is to say, they have to tell their migration history, they have to tell their truth, and they can be subjected to an assessment in order to obtain the residence permit. But telling the truth has a therapeutic value, but It also involves a political value as for any witnesses. And so the dimension cannot always be public, private, and legal. And so what is the value that we should give to the experience of narration and to the reasons, that is to say, the narration of the trauma concerning the reality of the experience lived, or if this is due to the level of truth, a series of words, and the person can represent his or her.
Le commissioni territoriali sono chiamate a valutare l'attendibilità dei fatti narrati e le esperienze vissute, sancendo spesso con le loro
This dichotomy is at play when territorial commissions have to assess whether the history told by the migrant is reliable or not. Intentional trauma is the so-called induced trauma, a trauma that was created by human beings by their ideological constructions or beliefs. These are nothing else but their expressions, a way to represent their concept of the concept of their relationship with the others, based on violence, on exploitation. The power of trauma, therefore, is telling us that the system is not human system. So if foreign children in Italy enjoy the right of education, health assistance, a safe place to live, guardianship if their parents are not able to be with them. At the same time, they are subject of assessment, of investigations, of judgments as to their reliability and as to their behavior since they arrived in Italy. So if on one hand, children cannot be sent back to their countries, on the same time, if there are reasons of public order and security, they can be expelled. The application has to be assessed by the juvenile court in a very timely way, within 30 days. So what may be the causes for a child to be expelled? For example, it could the child may feel to be fully misunderstood, that his questions are not taken care of, and his needs are not properly met by the center's workers. Centers workers are often lack proper training, so they often have to call police in order to contain, for example, as an aggressive behavior of a child who feels to be misunderstood or not understood at all, who even feels to be tortured and suffers from post-traumatic stress disorder caused by his previous life experience, his experience at sea. Now, to conclude these reflections on the subject of justice, migrants, and their acceptance in Italy, I would like to explain once again what I said before by talking about Rasoul. He is a child from Senegal. He was reported to the to the clinic for unaccompanied foreign children where I work. He was reported for some aggressive behavior and for not abiding by the rules of the center where he was living. He is a Muslim, speaks Wolof, and Rasul, until he was 8 years old, he lived with his family, his father, who was a farmer, a housewife mother, and other 3 brothers. When he was 8, he actually became more independent of his family, and he wanted to spend his free time, with friends rather than working. So he was entrusted by his father to his own brother, in other words, to Rasul's uncle. But the education and corrective methods applied by his uncle were highly violent. Rasul was beaten many times, and he was treated differently from his cousins. And obviously, these education systems did not work at all with him, but he tried to accept the decision by his fathers. Rasul never mentioned to him, when he was able to talk to his father, never mentioned what was happening to him in his uncle's house. And he never mentioned that he wanted to go back home. Then, as soon as he had grown up and was able to face his uncle, he was invited to leave. Again, it was another rejection, the same rejection he had already received from his father and his original family. Hence, he decided to leave his uncle's house without any plan ahead of him. Since then, he broke all his ties with his families. In Libya, he stayed there for 10 months, and he was in prison twice. The second time when he tried to reach Italy on a rubber boat. He was caught by Libyan police, and he was brought back to prison, where he underwent physical violence, and he was subjected to the so-called falaka, beating on his feet. He tried the second time he tried to reach Italy. He succeeded because his rubber boat was rescued and he was brought to the port of Messina. Once he was assigned to the first acceptance center, Rasul actually showed all symptoms of PTSD, post-traumatic stress disorder. He was always angry. He could not tolerate any request he was asked to do, any request that carried an authoritative tone. At night, he had nightmares where he would relive all the previous violence. But this behavior he had was in contrast of the other psychoeducational projects proposed by the center. The objective actually aimed at an integration, but this integration did not mean that it was really accepted by the community. So Rasul started to go from center to center, and nobody actually understood that whenever the police was called in, and whenever it was decided to move him to another center, all this would actually increase his PTSD disorder. and nobody actually understood what Rasul's feelings were actually in all this process. In addition to this, all moves from center to center never considered Rashid's needs, Rashid's demand. Rasul, with his action, was getting to a worse situation from time to time. Hence, he ended up to our clinic, where we tried to try and show that we were supporting him. We were on his side. We were not expecting anything from him. We did not want him to follow schooling or to attend school, etc., etc. We just wanted to be with him. We just wanted to show that we were at his side. Many times, even if we were not physically in presence with him, we would just text him or send him a picture. All this was very helpful for him, because he, in this way, felt to be supported. One day, in his WhatsApp profile, he posted a photo where the name of one of us had been written on the beach, on the sand. In August of last year, Rasul actually was finally heard before the so-called territorial committee. And only 20 days ago, the committee answered his application. So Rasul was believed, and Rasul was not believed, and his international protection application was rejected. At this point, Rasul said that he did not want to continue with an appeal. He had been confirmed that his words were meaningless, that nobody would believe him. Rasul came to visit us a couple of times later. He was very much disappointed at what had happened, but he said, I don't need anybody, I don't need anything to live. But sometimes he was really desperate. After almost 3 weeks, the community's manager told us that Rasul had not come back to the center. We haven't heard from him anymore. There was only one picture we saw on a social network that the center manager showed us. He is away from Sicily. At least we were happy that he was still alive. But again, Rasul will still be with us. We will always remember him, because of what was decided by our governments, by our leader. All these persons, they are marginalized, and they are placed in very difficult conditions, and they have to feel the shame of not being accepted by the community.
To this audience today, of the story of your professional experience. It was really, really, really deep, a deep moment of our conference. I really would like to thank you also for the emotions probably that you kind of generated with this intervention. And now it's open the floor for questions. We already actually have some questions in the chat. So we start with a question for Pippo from Bruno. Do you think it would be useful to collect information about reception center, care arrangements, and about legal guardians during an individual assessment in criminal proceedings? When it involves unaccompanied children, of course.
Yeah, I think it would be extremely useful, especially because as it was also mentioned by Dr. Vinci, we have to consider the story of the individual from a holistic perspective, out of any bureaucratic situation. I think we have to understand what was before and what will be after. Most of the time in the system, we are limiting our relation with people to a bureaucratic dimension. And we are asking kids to tell again and again their story without understanding it. So I think valuing all the elements of a story out of a bureaucratic perspective, but in line also with what participation, the real meaning of participation mean, no, which is not just, okay, let me know something, but is to consider the story of this child as part of our story, as part of our profession, as part of our ethical commitment. So I think that any kind of way to understand more about the life path of a person is very important, but it is also a very delicate matter that has to be done with appropriate competence and appropriate ears. We have to listen, but we have to prepare this listening in a context that makes sense also for the child and not just for the system. Thank you.
Thank you, Pippo. Another question for Alberto. Steven was really interested in your perspectives as to what the purpose of individual assessment should be in a case such as that one faced by Khalid. The question in particular is about how we can prevent this phenomenon of criminogenics.
Criminogenic. I cannot start my video. I don't have to, but oh, okay, sorry. Here I am. I'm back. So no, Stephen, I think it's a fundamental question, the one you're asking, and there's various layers to that. Well, the more fundamental level, I think we need an individual assessment because minors are not presumed, at least in Italian law, to be capable, to be mentally capable. Under 14, you're not capable. You cannot be tried and found guilty. Between 14 and 18, there needs to be an assessment as to your level of development and your ability to understand what you're doing. So that's the most fundamental purpose because it might rule out criminal responsibility altogether. Of course, we're talking about extreme cases and it depends on the crime. It depends on a lot of individual circumstances. But if your mental development is not sufficiently, how can I say, is not sufficient, then you might be even considered as non-capable. And then we need this assessment. If they find you to be capable, then there is something in the juvenile criminal proceedings which is a sort of pardon. And so if your conduct is, not that serious, it's not reiterated, it's an occasional deviation from the right path, then you might get even pardoned. But that presupposes an assessment of you as a person and your background and your conduct. at the very least, an individual assessment is needed in order to apply mitigating circumstances. And this is like I heavily relied on Khalid's turbulent past to prove that he, you cannot compare his situation with that of a spoiled Italian kid who was brought up by his family. He got all the good teachers and the good principles, and then he intentionally decides to go and to do something wrong. So the mitigating circumstances, what we call generic mitigating circumstances, are non-predefined circumstances that go in favor of the accused. And the court, the various judges that tried this client and many other clients, of course, they relied on the assessment based by the social services that proved that this person, well, he has a troubled past, and this must be taken into account when meting out the punishment. Is it your view?
Yeah, you can.
There's a follow-up question. Is it your view that defense attorneys should drive the individual assessment? Could that be beneficial? Well, what I don't think it's necessarily, well, certainly it's not a prerogative of defense attorneys. I would argue that it is the system that should take care of that, and defense attorneys should benefit from the system's assessment. Defense attorneys do not have the type of day-to-day contact that social services might have with the person. The lawyer's job typically is to meet the client, to prepare the case, and then when you do these kind of cases, you go a bit beyond sometimes what are your duties, but the system cannot expect from lawyers to do this kind of job because one, it's not their primary job. B, they might not have the necessary competencies to carry out a more like 360-degree assessment of the person. But yes, when the system is somehow weak or slow or failing, then lawyers, it's a good idea for lawyers to push the system and in some cases even to drive it. But again, I don't think that should be the rule. It should be the social service, the public system that should drive, not private practitioners like lawyers.
Thank you so much, Alberto.
Yep.
There is a question even for Sebastiana. Well, it's related to the training that is provided to the workers from the commission, the territorial commissions, and if you know if they are following some guidelines to assure how much the declaration of the children can be taken into consideration. So it's related to the training background, let's say.
La formazione dei partecipanti alle commissioni.
The training of participants in the commission. So this is known. I think that there is no personal training, but only theoretical, let's say legal, in addition to the human resources and the managers chosen by the ministry. There is a representative of UNHCR, and then there is the boy or the girl who is accompanied by a mediator of the commission and gives his or her witness. Recently, in order to avoid an unimaginable situation, what are we doing? We prepare the boys and the girls before participating in a hearing. They are prepared to tell their story to the members of the commission. What Quite often, mediators cannot understand the witnesses in the original language, and so they lose a series of meanings, of shades that in the language have something else, not only a simple narration of facts that happened. And so sometimes we have to reread with the boys and girls the reports of the commissions, and the boys and the girls quite often say, I've never said that. I've never said this thing. I didn't say this thing. And so the issue is here, the problem is here. If we have to talk about training, I don't think that the members of the commissions have to be trained from a legal point of view only. I think that the training also concerns the aspects associated with the listening of the story of the boy or the girl. Certainly, there are some rules, some laws that have to be complied with, but I don't think that laws and rules can understand the narration that implies other scenarios. A subjective dimension that the law, unfortunately, cannot understand. It is not within the laws that we have in Italy. So the issue of training suffers, between inverted commas, from this gap. We cannot be competent only from a legal point of view. We must be able to listen to the suffering of those who speak. Thank you, Sebastiano.
One last question, as people is raising up his hands, and then we'll have a really short break. Sorry for the delay compared to the original agenda, but we hope at least that you are enjoying even all this reflection and comments. So, people, here you are.
Sì, una domanda volevo fare al dottor
A question to Mr. Vinci and Mr. Pasquero, because I think that Mr. Vinci is very interesting. So one professional is a psychologist, the other is a lawyer. What is the element? What do you think that we have to take into account as professionals of various disciplines? Something has already been said, but what type of feelings, what type of ethical behavior we should have in acting as a professional, as educator, psychologist, a lawyer? Is there an element that you can share in terms of your experience? This is a wide question, very interesting question. I think that I can say this, that I work, we talk about foreign children, and so I would say the aspect of cultural mediation that goes beyond the translation of what is said. It goes towards the meaning, the comprehension of a culture of origin, the values, what the society expects from the person, and what is legal or illegal or socially accepted. Sebastiano talked about the credibility of the narration. Sometimes the failure of the system is to consider non-credible narrations that are different from what we would expect in our culture, because we all are within our culture of our country of origin. So we have to welcome the other person. The person is the product of a culture of origin, and this is the effort that is lacking. The approach to try to understand with the glasses, with our mentality, because we have our own culture of origin. If we talk of children in general, this is something taken for granted. The approach to be taken into account is re-education, rehabilitation. So prison and rehabilitation are in conflict, they clash in an obvious manner, because prison is because the prison creates crimes, and there are children who spend their best years of their life in juvenile prisons that are the preparation for new crimes. But first of all, these children need a second chance to know, to understand why they were wrong and why there was this behavior of crime. And so instead of repress these kids.
Add something else, as the question was addressed to both of you.
No. Solo un cenno a...
Only, but the lawyer Pasquale has already said the problems that a commission could have. The issue is also concerns another aspect linked to prejudice sometimes, and to another factor of witnesses, the fact that sometimes we don't want to know. Sometimes with some narrations of tortured people, so the horror of listening leads us to exclude from our consideration what we are listening at. So there is this issue of prejudice. For example, someone says narrations, the stories are all the same. There is a construction of the witnesses. I think that in this case, there is a sort of removal mechanism, a psychological removal mechanism that is triggered when these stories are told, because they are it's very difficult to hear these stories because they are horror stories.
Thank you so much, Sebastiano, and thanks to all the panelists that have brought their contribution during this first part of the morning. Now we'll have 10 minutes break, and at 20 to 12, we'll start again with the session 2. We hope that you enjoyed the small break, just to refresh your minds. And I would like to welcome the panelists of the session 2. During this session, we'll be presenting the EU model for child-friendly courts, and the session will be moderated by Bruno Montero from Validity Foundation, the leading organization of the project. So the floor is yours, Bruno, to introduce and moderate the session. Thank you. Enjoy it.
Thank you, Tina. Good morning, everyone. It's really a pleasure to be here. So essentially, for those that weren't around yesterday, just to briefly introduce myself, My name is Bruno Montero, and as it mentioned, I work at Validity Foundation, which is an international NGO headquartered in Budapest, which promotes the human rights of all persons with disabilities, including children. I manage the Child Friendly Justice Project, and it's an honor to moderate this last session. So essentially, this session just aims to be very practical, where we will present and seek your input on 3 different models and protocols to address one of the main questions of this conference, of how individual assessment should be conducted for children with intellectual and psychosocial disabilities, children without parents, and unaccompanied migrant children who are involved in criminal proceedings. These are all activities within the context of child-friendly projects. And if you just joined us and you're interested in reading more about the project, you can easily read more by accessing the link, which I just copied to the chat box. On that note, and just provide also a bit more background. So throughout this conference, you heard about different practices, legislation, and measures to ensure appropriate support to enable children to participate, especially those who are involved in criminal proceedings and who are in a vulnerable situation. You also heard about how individual assessment, depending on how it's used, can become a useful process to identify and decide how best to support the child in this situation. This is why Validity Foundation, Bulgarian Center for Not-for-Profit Law, the Center for Legal Resources in Romania, and PRISM in Italy, we've all partnered to ensure then the individual assessment process are tailored to each child, and have worked together to develop practical tools in the form of models to achieve child-friendly reform. So in this session, each speaker will have about 15 minutes to present an abstract principles and highlights of their model, which they're working on. And after their presentation, the speakers will invite you to answer a poll to help decide the direction and think of a solution to key questions. There were already several issues and questions that were covered throughout the conference. So this will be a moment where you'll be able to give your answers, and the answers could actually help shape the model that each organization is presenting and they're working on developing. Just to note, the answers to these polls will be anonymous, and each speaker will read out the question and multiple choice answers. It is our hope that this will help to have a fruitful discussion, and nonetheless, we will have a Q&A session at the very end of this session. On that note, and without further ado, I'd like to introduce the first speaker, Nadia Shabani, who is the Director and Legal Consultant for the Bulgarian Center for Not-for-Profit Law. Nadia has developed projects in the area of legal financial framework of civil society organizations in issues related to good governance, organizational development, decision-making, and advocacy. Nadia has also been the chairperson of the Bulgarian State Agency for Child Protection, where she has been in charge with coordinating all relevant government policies in the field of children welfare area. Nadia has also built her expertise in child protection by collaborating with several profile organizations such as UNICEF, UNDP, European Commission, Oversight Institute. And it's a pleasure to have you in this conference. So Nadia, whenever you're ready, you have the floor.
Thank you, Bruno. Nice to meet you, all of you. I am very happy that we managed, nevertheless, it's online, to make this second round of discussion around our important topic. Can really the justice be child friendly? Let me now just try to share the screen because I have prepared, I hope not too long. Just a second. Okay. Bruno, can you just say, is it visible?
Yes, it is.
Okay, so as Bruno and Tinea in the previous session mentioned, we, after each of the partners, we developed our country reports, and our goal was to prepare a better solution for reaching the best standards regarding the child participation within the justice system in different contexts and having the current legal framework. So our task was not so easy because from the legislation point of view, I will say that the Bulgarian legislation is developed well. Of course, there are some gaps, but the problem, and that was very clear from our research, is coming from the practice and how this legislation is implemented. So we decided that within our model, we will try to introduce not so much new legal solutions to the problems, but practical tool that can be used from the professionals to achieve the set by the law goals. So we called our model is, the goal of our model is to safeguard children's rights and best interests to an effective. When we say effective, we mean that it's really achieving the goal of defending children's rights within the procedure and respectful participation in the procedures. And the key milestone for this, we introduced the interdisciplinarity as a model for trying to achieve those goals. Why we do it, as I said, to really improve the manner in which the child is participating within the procedures and ensuring a real dignity of the child personality, and also within this process for us a possible solution that is meaningful is to try to build more stronger bridges between the child protection and social care system and judicial system. Here, when we speak about this, we do not mean only those professionals to meet in a certain stage of the process, but to have common goals and common plan that they should implement together. In this multidisciplinary, we really want to introduce I really do not like the cliche to put the child in the center, but the idea is really to organize the system in a common development plan to serve the best child interests and rights defense. What is our starting point for our vision for the model is, of course, the model to be in full compliance with the Child Rights Convention and all the international best standards related to children's rights. Fully integrate the timely, and we will speak about the time in the next slides also, and multi-sectoral approach as an effective tool of justice meet the child protection system, and in parallel to be sure that all the safeguards that are important are on place, procedural, material safeguards, professional preparation, and of course a lot of social measures that are supporting the child. And do not forget, we should not forget the family of the child, if such is in the environment of the child. Few words about the context in Bulgaria, our starting points. As I said, we have pretty well-developed legislation. Still some things are missing, but the key problem is the lack of coordination between criminal justice, child protection, and social services system. The only meeting they have mainly is happening when in some of the cases, the justice system is asking for some reports, but we are not sure exactly what is the value to the procedure of these reports. And in these cases, the cases that we evaluated within the research, the individual assessment, in fact, if it's implemented at all, it's primarily serving as an evidentiary tool within the process, rather than to be a good map for securing the rights of the child within the process. And huge underestimation of the training of the professionals, including the cross-sectoral training that, from our point of view, will be more meaningful and will support the professionals really to develop together a common idea how to ensure the rights within the process. In our model, we want to test such kind of trainings that can really ensure the interdisciplinarity in an effective way. So in the model, 4 elements, let's divide them like that. Of course, each of them is developed in a more cascade way. Procedural rights that are tailored to the best interests. And for sure, within this package of procedural rights, the individual assessment and the hearing of the child are the key milestone. Trained professional, all the professional that the child will meet within the procedure from the very early stage. Supportive environment with all the elements that will make this environment really supportive and enabling. And appropriate infrastructure where all the measures should happen. Nevertheless, they are a supportive measure, or they are ensuring some procedural rights, like the hearings. Here in Bulgaria are popular the so-called blue rooms, which are the special infrastructure when it is supposed the hearing of the children will happen. And there are 2 approaches. One, we think it's not very effective to create those rooms in the court palaces, which is an easy opportunity for the court and the lawyers and the prosecutors. But we think that the best way for building this infrastructure is to be within the social support system, which is more friendly, and the justice system to move there and to organize the procedural stages there, which is possible from the legal point of view, but hardly is happening on the practice. So the principles, 3, they're simple, but it's really very hard to ensure them in details within the procedures. Decentralization of the decision-making, including to have more possibility to decentralize some of the decisions that has to be taken, especially regarding to the support measures to be taken by the social system. Strengthen the multi-sectoral and interdisciplinary, as I mentioned, not only like asking between the system different kind of special opinion that can be provided, but to establish common evaluation, and after that, which is more important, a common implementation of the plan, if such is developed after the individual assessment, and in this plan to be included all the supportive measure that is needed, and timeliness and effectiveness of the preventive and protective measures, of course. Here, I'm going to illustrate what we speak with one case. Of course, this is not the true name of the the child was from a minority, Roma minority, in a very rural area. The mother was a prostitute, and when the child was 10 years old, in fact, he was living with his smaller brother at home alone. So they were attending some school classes, but because they were hungry and there was no food, and the social system, even that they had some information that those children are alone at home, didn't took any, in fact, they were not abandoned by their mother, didn't took any action. And after some months, those children stole some food from the school small shop. And of course, after that, there were some not exactly social protection measures, but some restrictive from the school measures against the children. They repeat this action after 2 years, and after that started, according to our system, it was some procedure that is trying to put some punishment to the children, and they escaped. After that, they went to another city, they become bigger, and when the Mario was 16 years old, she was part of a narco trafficking group, and of course, there was a crime, and after that, he was sued. So this case was absolutely, within this case was absolutely obvious that the systems are not working. The prevention that was possible to happen, even in the school stages and the social protection system, it was possible to take some action and to work after that with all the stages from the other system, but this cooperation was just sending between the systems some information, which was ineffective at the end because it didn't really complement and add some value to the case of Mario that can help him to stop and to try to find another way for supporting them to take out from this environment that in fact pushed Mario to do the crime that he did. So regarding the individual assessment, it is, as I said, a key milestone within our model. But something that is important to underline regarding the individual assessment, that beyond the general information that we can see in the most of the cases, in the easiest part and the fact that illustrating the personal story, it is important to cover also some issues that are related to the environment. If we turn back to the case of Mario, it will be important to add information about the family, the mother, the possibility to find some other relative that can be supported to take care about Mario and his brother. And here it's come from our perspective, the very important part of the individual assessment that should analyze the experience, if there is a violence experience and the family, it's important to evaluate also the family capacity to meet these needs adequately. Also, something that is generally missing, but if we have it in the individual assessment and if it's happened timely and in the very early stage, it will have crucial effect on the protecting child interests, is the risk of re-victimization and the possible factors that are related to this. Very often within our research, we met cases that nevertheless we have some procedural safeguards, and the hearings are happening in the so-called child-friendly environment, like the blue rooms. There were like more than 5 hearings, one after another, to clarify the violence, and they were asked by different parties, defense party, the prosecutors, and for sure if the child was a victim in these cases, so there was no measures against the re-victimization. And something that is crucial is to have this appropriate evaluation of the child needs related to additional educational and social support that can be ensured really to help the child to protect the child's rights, but also to ensure the child needs. So the algorithm includes a good appropriate tasking and question in relation to the report requested by an authorized institution. And here we are going to speak later which should be this institution and on which stage we should push the button to organize the individual assessment. Shall be in the very early stage, where the child protection system will have the contact related to the case, or when the judicial procedure will start. In our group, we have still the discussion, and it's not so much from the perspective what is allowed from the legislation. Everything is allowed if it's not forbidden, but it's more related to the culture of these systems to work together and how valuable is sharing the information between each other. Here in the algorithm, and it is very contextual, I'm not sure it's relevant to the other system like the Italian and the Romanian. We put some advices to how our core system can work, especially with the child welfare services providers, to ensure the support within establishing the safeguard within the and ensuring the procedural rights, but also in trying to do this individual assessment or to organize the process related to the individual assessment. Of course, our focus within the algorithm was the criminal justice procedure, but during the discussions, and especially with some of the judges that are looking child civic procedural cases, including parental rights cases, they said that even in these cases, the individual assessment in some of them will be important, but it will have another focus to determine the most appropriate manner and condition of the child and its meeting with the court.
Nadia, 1 minute.
Yeah, I'm finishing, Bruno. So I here want, because we the interaction with the audience is really hard in this online facility. Just I want to underline 2 things. My organization, we are working in the last 20 years to try to develop the legal system, but already we know that it's not enough to have good rules. We already have the best international standards. According to our constitution, even if the local legislation is not implementing them, we can have the direct effect. But when we go in the practice, we see that we need more than this. We need more than good standards and vision about how we want to see the child in these procedures. So within these models, we really try to give to the professionals that are involved, to the system that are responsible, new instruments, how to work in a collaborative way and co-create together the best decisions that are related to the child. And we believe that in this way only, we can have the best child protection, the best protection of the children's rights, but also those will serve the judiciary system and the child protection system in the best way, and they will achieve their goal that they put within this process. And we are going to see how it's going to work on the ground. But here I want to open for discussion 3 questions that were part of our internal dilemmas, really from the perspective which of the possible solutions is more effective on the ground. The first question is, on which stage shall the individual assessment will be developed? And now we are going to put this as a poll among you, so it will be interesting to see the answers. But as I said here, the dilemma is between, shall it start from the first meeting with the child protection system? It should be the first meeting with the child protection system, or the pre-trial process, or in the trial process. Who shall ask for the individual assessment? Who shall be the authorized institution that will facilitate this process, which is different from the third question, who shall do the individual assessment? And the second question is really important because depending to the answer, the individual assessment will have different value. If the court is asking, it has one value. If the one of the party, the defense lawyer, is asking, it will have another value. And who shall do the individual assessment? It's also a key question, because generally, in these ways, the experts within the court, which are mainly psychiatrists, are doing this, but we do not think this is really effective. If we really want to have the big picture of the child's history and development and the factors that are making sense to his or her story, we need more how to say, we need different professionals, and maybe we need a common task to give to them. And here will be also interesting to see your answers. As I said, within our model, we want to introduce the idea that it can be organized in interdisciplinary manner, that can bring more information and more valuable information to the court or to the pre-trial process, that can serve the proceedings, but also to ensure that we have a good supportive plan to the child. So I'm not sure how we are going to organize now the polls.
Sure, Nadia. Stefano, whenever you're ready, you can start the poll for the first question.
Okay, here is the first question. On which stage shall the individual assessment will be developed? You have only one single choice: immediately after the first contact of the child with the protection system, in the beginning of the court procedures, which is the second option. And the third one is when there is a need to take social care measures. And Bruno, I will read the second one as well, right?
Yep. Read the second and the third, please.
Who shall ask for the individual assessment? Here we have only one possibility to answer. We want really to make the comparison with which has the most: the social department, the parents, the court, the prosecutor, and the legal aid advocate, the defense lawyer. And the third question is, who shall prepare the individual assessment? Social worker, medical specialists, psychiatrists, child carers, all listed above in a coordinated manner.
We're really curious to hear your answers. Like I mentioned in the beginning, the answers will be anonymous, so you don't have to worry. Each question only, of course, there are several possible answers. Although we're curious about which one do you think works best in your view. We'll have the poll open for 2 minutes. And just to give you enough time to think about it and consider the different aspects of the model that was already presented by Nadia, and also considering everything you heard so far from the conference.
And I will say, if I may, Bruno, that possible solutions are how to say, are meaningful, but here really the dilemma is what will serve the best the parallel goals that we have, best child interest, but also serving the different procedures that we have ongoing from legal point of view.
For sure, and like you described, there's definitely a lot to be done in Bulgaria. And as mentioned earlier, this is your answers here, both to this poll and to other polls, will just help shape the direction that each model will take, and will help shape reform in each country.
Hi, Bruno. This is Stefano from the control room. We're just going to leave a little bit of more time. We invite everyone to, of course, to complete the pool. So far, about the 25% of you did it. So we invite you to just join the pool. It's anonymous, as Bruno said, and we're just going to give you another minute, and then we'll go through with the results.
And thank you once again for your input. It definitely will help the 4 organizations working the Child Friendly Justice Project to think more, to continuously think about this topic. So just select the choice which you think it's best, considering everything you heard. Only one single choice for the 3 questions.
Okay, this is the last 30 seconds for the pool. So, so far about a third of the people answer. We're going to go through results.
Yeah. After 30 seconds, we can close. Yeah.
Yes.
Thank you, everyone that answered. Very interesting answers to the question. So it looks like the answer that was selected the most was, for the first question, was immediately after the first contact of the child with authorities, if I'm not mistaken, with the protection system. Then for the second, interesting. So there's a mix between social department, legal aid, the advocates. For the third answer, the selected was all listed above in a coordinated manner. So you can see now that there's a lot of work to do to just ensure the multidisciplinary approach, like you were saying.
Yeah, I'm very happy, if I say one sentence. I'm very happy about the third answer. I think the second is very interesting, and there are plus and minus for the 2 options. I mean, the first and the last one, the legal aid and the social department. But thank you very much. I think it's helping us really to deeper even our ideas about the interdisciplinarity and the timely support and assess of the child needs.
Great. Thank you so much, Nadia. Wonderful presentation and very thoughtful. Thank you so much. Then we'll move to our next speaker, who you're already familiar with. Our next speaker is Giuseppe Vita. He's a social worker and legal expert in the field of humanitarian rights and international protection. He has extensive experience in working with international organizations and several NGOs. He has worked at UNHCR, the United Nations the High Commissioner for Refugee. And his work there, he's supported and participated in the recognition of refugees and vulnerable people in need of international protection. He's now collaborating with PRISM to support the activities of the Child Friendly Justice Project and on developing the model to address vulnerabilities of unaccompanied children who come in contact with the criminal justice system. Giuseppe, whenever you're ready, the floor is yours.
Thank you, Bruno. Hello, everyone. I just cannot turn my camera on. I just asked support to the service. I can turn on my camera. Well, here I am. Hello, everyone, and thank you, Bruno, for the kind introduction, and thank you also for supporting us and me, especially in designing and shaping this model. This model that, let me say today, it's I feel very good because it's like having worked for something that it's just building the base, a construction of a confrontation with other stakeholders in order to think about a model. Why do we need a model? So today there's a new inputs and more inputs to continue to do this work of the creation of this model. Our model is definitely based on a target that is unaccompanied migrant children, and it's clearly different than the one that has been treated by our colleagues Nadia and also Georgiana and Oana from the Romanian team. So today I'm going to share with you a presentation. Hopefully it will not be too long. So the first, consider that this model is coming out from the activity research that has been conducted. Can you see the presentation? I hope so.
Yeah,
well,
it's working.
Well, this model is coming out from the research that has been previously conducted by my colleague, Antinea. And the research obviously is based on interviews with prosecutors, judges, and other professionals that are active in place when we talk about criminal proceedings, especially criminal proceedings where we have children involved also. Clearly, we started our individual assessment model asking ourselves why do we need an individual assessment procedure, and why do we need a model to think of a procedure of assessment? Because simply there are three reasons, and today listening Pippo Costella's presentation and also Alberto's one, we understand that there is there are rules, there are regulations, international regulations and guidelines, but there still need to implement in practical actions. So individual assessment procedures can offer a chance to have a better protection when we talk about victims, and especially protecting victims from a secondary victimizations. But also individual assessment procedures can be useful when we design and we think about children reintegration. And I think in this case, when we yesterday spoke about the work of the USSM office in promoting projects for the reintegration of children offenders, obviously. But overall, those things, individual assessment procedures could enable a participatory process among all the actors and the stakeholders for the first thing that is called the best interest of the child. Definitely, the individual assessment is towards two main points. One is the individual level, where we see that the child receive a fair treatment, and especially the involvement of the child is considered a priority. And the other direction where we see that individual assessment is a priority is for the system. The justice systems can optimize the resources that he has, and can also, assure a better judicial action in terms of effectiveness also. What is important to remind is that the individual assessment procedure, it's a process that is based already on the standards of human rights and the implementation of human rights as well. So clearly, has been cited and mentioned by my other colleagues before, but the Child Rights Convention is the base, is where we come from in terms of work, and it's the first binding instrument that has been promoted, that talks about this multidisciplinary approach or holistic approach. That is actually the things that is common in the three models, and you will see it even later with the presentation of our colleague. When we move from the international legal frame and we go to the European one, we see that speaking of victims and suspect or accused person of having committed a crime, we have two different directives, specifically in terms of individual assessment. The Article 7 of the Directive 800 from 2016 highlights the needs of the child with regard to protection, education, and training and reintegration. And in this case, we are talking about how to work to support reintegration of a suspect or accused person. At the same time, the European Directive and the Article 22 talks about the individual assessment procedures that needs to be carried out when we talk and we deal with victims of a crime. And this stage is particularly important to promote, to understand which are vulnerabilities, but also to understand which are the protection needs that the person has. Moving to the best, this model, as I said before, is coming out from the research that has been conducted, but is also coming from an analysis and a research that we have conducted in terms of understanding which are already good instruments and good tools that could be adapted and applied in other contexts. And in designing the model, we thought about the best interest procedure that has been designed and also updated by UNHCR. It is published, and it's a procedure that provides quality standards that can be used primarily in the context of recognition of international protection, but adapting those tools, it's possible also to understand that in the criminal proceedings, there's still a space and a spot to work to improve the multidisciplinary approach. We also took in consideration of the guidelines promoted by the International Working Group on Child Protection, and where we understand that working in a multidisciplinary way in case management, it needs to have an approach that is definitely coordinated. In the Italian context, we see, I'm going a little bit quick on this because yesterday and even today we've been talking about the 448, that it's the presidential decree. I think there's a mistake in the slide, but anyway, we already heard of it. It's the Juvenile Criminal Procedure Code in some way, so-called like this, but even if it was 1988, the Italian legislation provided something that it's, let's say, it has been very important, very interesting in terms of implementation. And I'm referring to the terms of the Article 9 of this code, where we see that the judge and the prosecutors have the power to start the action of individual assessment, and also the importance of the Article 28 of this decree, that it talks about the probation time and the juvenile probation, that it's considered as a good starting point in terms of reintegration. In terms of protection for the victims, in Italy we transposed the European directives, and there's been improvement also in the national legislation. There was a change of the Article 90 of the Criminal Proceeding Code. Why do we need an abstract model of individual assessment, and why do we need it when we talk about criminal proceedings? Before, if I recall correctly, Sebastiano Vinci was talking about the importance of caseworkers and people who take decisions, among other people, to be trained, to be prepared. And that is not only about having judicial knowledge, but it's having an analytic knowledge in terms of approaching to the multidisciplinary work that has to be done. Includes also that there's a need to improve other skills. So we think that a model that can also be implemented in the criminal judicial system is a model that is inspired, for example, of the collection of information. Before, it was mentioning something like this, that the cartella sociale. People was talking about the importance in the Italian frame of the law number 47. This law is so-called the Zampa law. Zampa is the name of the person who wrote the law. It's very important because it brings new elements in the one that is probably the administrative field work or the immigration field work, but new elements that can be also can find a utilization also in the criminal proceedings. And I'm talking about not only the role of the guardians or the role of the cultural mediator that we will explore later, but one of the first instruments that has been introduced is this cartella sociale. Cartella sociale is nothing else like so could be called a social file. It's a document that doesn't have to be considered as a bureaucratic tool, but is to be considered as an operating tool. Well, all the professionals involved in procedures of individual assessment can put their observations and their informations in terms of evaluation of the person. And the main idea of this cartella sociale is not to prepare a document that doesn't have any scope, but it's a document that can follow the child in all his movements. And we know that the reception systems is quite articulated, at least in the Italian scenario. So this document has to have information on the person, but that can be also useful in terms of frame of vulnerabilities and relevant information on cultural, behavioral aspects and other elements really close to the person. The use of this social file is like a tool that can support, for instance, when we talk about secondary victimization, and having already some information about the person can avoid it to stress the person in having multiple interviews and repeating every time the trauma that is always connected to his or her personal story. Our colleague Nadia was mentioning the blue room, that it's another good thing that it's in some way bring us in common or give us common grounds to work on. Blue rooms, it's a model in terms of where people can, where children can be heard by the judge, by the prosecutor, and by the other professionals. Among other countries, there's the model that is called the Barnhouse model, that it's developed in the Scandinavian countries and spread around Europe and also the United States. The Barnhouse model, it's a model that it's the concept of the one-stop shop, where everyone that has to be involved in an individual assessment proceeding can go to have the interview with the child in a protected and safe environment. In the Italian context, we see that we don't have a specific model on this, but definitely it's important that every person that has to establish a relationship with a child, that has to do an interview with a child and an accompanied child, has to consider a couple of things as important. One is the setting where to conduct the interview. It is important to be sure that there are basic things to ensure that the child feels protected and protected by the different types of elements that can create distractions and can create also ansia. The preparation of the interviewer, it's also another important thing. As Sebastiano was mentioning before, preparation. This is something that it doesn't involve only the aspect of knowledge or being prepared on terms of knowledge of rights and duties, but it means also mentally prepared to afford an interview with a child that has been suffering a trauma. Another aspect that it's important is knowing the child. Interviewing a person is not only fulfilling and trying to achieve the personal goal of the interview, but it's also establishing a relationship with a person and getting to know the child is a priority. Another thing that it's quite important, it's explaining the procedure. And it's important that the one who is in charge of conducting an individual assessment has to explain to the child what is the procedure that is going on and which are the possible outcomes and consequences of the interview. It is of a priority also to maintain a communication that is based on trust, relationship between the person that has to conduct an individual assessment and the child has to be based on trust. And it's also important to remember that when there is an interview with a child, it's like opening a box and trying to, you know, bring things outside of the box. But then it's also important to close and to help the person in closing this box. Going back to the point of preparation of the interviewer, we think it's a tool that has to be more implemented in the frame of the criminal justice for child, and it's the use of the COI. It's a tool that has been developed already and pretty much used also in other contexts like the International Protection Recognition Frame. Why it's important to have a knowledge about the other countries, the countries of origins of unaccompanied migrants, because it's basically there's a dimension. Sometimes let's think for instance about a case of a young victim of trafficking. There's definitely a dimension of the crime that it's a local one. It's the one that brings the person, that conducts the person to the criminal proceeding. But there's also an international dimension that has to be at least understood by the person who is in charge of the individual assessment. And understanding the general situation of the country means having knowledge about human rights, security situation, political situation, cultural aspects, and other humanitarian information that are relevant in terms of general knowledge about the person. This is a resource that has to be, it can be used by the police, by the prosecutors, by lawyers, by psychologists, and all the other professionals who come in touch with a child. Now we go back to the point of the cultural mediation role. The legge Zampa, the Zampa law, introduced officially this new figure. It's a bridging figure. It's a bridging role between two different contexts, cultural context, and usually the cultural mediator is an interpreter as well, but it's not the interpreter. The cultural mediation is the kind of professional that can just put more close and try to reduce the distance between an unbalanced, let's say, position between the interviewer and the child. And knowledge is not only about language and things that are pretty related to the communication, but it's also related to other aspects more connected to the cultural environment of the person. We think that the role of the cultural mediation has to be further developed in the frame of the community justice system, not only to perform individual assessment, even if we think that it's relevant is its role, but also in other works and other services of the community justice systems. And I'm thinking about restorative justice and access to alternative measures like the probation time and other good ideas in this frame. What we think is also important, and today probably we can confirm this aspect, that there are rules, there are regulations, but we need to strengthen more on the coordination of the actions. The system.
Giuseppe, 1 minute.
Yes, thank you, Bruno. We are talking about a multi-agency or a multidisciplinary system that has to be coordinated, and we think that this role of coordination is definitely in the frame of the system, as Alberto was just suggesting before. It's the system who has to take the responsibility of carrying out individual assessment procedures. And definitely we don't look at the single level, but we look at the individual level, the organizational level, and the systemic level in order to promote a change. I just finished. Thank you for listening. And before closing, definitely we would like to ask questions that you can answer using the poll like before. The question number 1 is, in which terms do you think that the cultural mediator role is relevant during the individual assessment? is a single choice, and later when the service will show us the exactly. Thank you, Stefano. Question number 2 is which assessment can be considered relevant to complete an individual assessment procedure? Question number 3 is does individual assessment procedure apply to your work? Bruno, I think we'll leave other 2-3 minutes to provide the answers, and then we can show the results.
Yeah, just wait 2 minutes, and Stefano, if you don't mind, you could just let us know when it's 30 seconds. Yeah, before it finishes. Just as a reminder, especially for those that might have joined us later, the answers to these polls are completely anonymous, and this will help to shape the models that are being developed by each partner organization in this project. These polls focus specifically for the Italian model that Giuseppe just kindly presented, bearing in mind the specific situation of unaccompanied foreign children. But of course, any answers will be useful for the 3 models. So thank you so much for participating. We look forward to read your answers. Just as a note, Giuseppe, I just find so interesting the different proposals you make of potentially just using the social file in Italy to essentially just connect the information that's being collected in any case in the social protection system and try to connect it to criminal proceedings, and even connect a different database from the COI.
Well, consider, Bruno, that the cartella sociale is already known by the prosecutor. This is a provision by law. I don't remember exactly which article of the Zampa law states that, but the prosecutor office relevant for the juvenile court where the child is, where it's got the residency, actually, where the facility where the child lives is has to be notified. So in some way already prosecutors know the cartella sociale, they have at their disposal the cartella sociale as a tool of knowledge. Definitely it's probably more oriented on the discussion of how to have a better use of this information in order to promote, from one side, to protect children, and the other side to ensure that justice can have the justice system can have an amount of information usable even during the proceedings.
For sure. Wondering what do you think about about data protection, though? Do you think there will be any concerns, or is there something that's, from a legal point of view, something that can be easily overcome?
Well, Bruno, I was just thinking and probably reconnecting also to the presentation and the story told by Sebastiano Vinci this morning. I think we can overcome the issue of privacy, even because we're talking about tools that will be used in the frame of the national public system, and I don't see any difference, for instance, between the Territorial Commission for Refugee Status or the court or the prosecutor office. I don't see any difference in that. I think it's possible to overcome that. I think it will be better not only to think about how to overcome the issue of privacy, but the question must be how to work together to use a tool and to adapt and implement and increase also the value of this tool in order to collect informations, quality informations. That's probably the point that should be more focused on, quality information that can avoid, for instance, second victimizations, or can even support. Yesterday, when we were talking with the USSM office, they were talking about, positive projects of integration of young children, unaccompanied children who came into touch with the justice system. So having a disposal knowledge is always a tool that has to be more implemented and more developed. So we can just read a few answers, I guess.
Sure, very interesting answers. looks like there's not always an obvious answer, which just shows that how difficult it is to find the appropriate solution for the models.
Well, it's interesting because I see that few of them we have answers that were say at the first questions. Cultural mediator. The question was, in which terms do you think the cultural mediation is relevant during the individual assessments? I think that it's interesting that we see that cultural mediation offers supports to have a better understanding of the social and cultural context of the child. That's true. Actually, there was not a right answer, but probably the last answer that was the one that collecting the others as well. There's not a right answer, but definitely this is what we think too. I mean, it's cultural mediation. It's offered this and works in this direction to support to have a better understanding. Definitely true. Then on the second question, which assessments can be considered relevant to complete an individual assessment procedure? And this is probably speaking in terms of how to use and how to develop more the cartella sociale use within the individual assessment. This is true. All of them act without multidisciplinary approach. This is the base of our work, actually. Yes, we like to see that we, among our participants, we have a lot of people who are just involved in individual assessment procedures. Feel free to add any comment if you have one, or to ask questions. This is the right time to do it. Thank you.
For sure. Thank you, Giuseppe. Of course, like Giuseppe mentioned, feel free to write on the chat. We will have, in any case, a question and answer session at the very end, where we can ask even more questions aside from what was written in the polls, and we can have fruitful discussion of what models for individual assessment. Bear in mind the specific vulnerable situation of these children, unaccompanied children, children with psychosocial intellectual disabilities, and children without parents, on how best to use individual assessment to ensure they actually receive the proper support during criminal proceedings and enable them to participate. On that note, I would like to introduce our final speakers. Last but not least, I'd like to introduce you to Oana Dudu, who works at Center for Legal Resources in Romania as a program assistant and a legal expert in international and European law within the program Advocate for Dignity. She has done valuable work for persons with disabilities who are in institutions during the pandemic period through support and legal action. At the moment, her work revolves around helping people with intellectual and psychosocial disabilities in Romania. Alongside Oana, to also speak Liliana Kovati, who is a psychologist. And on that note, Oana, the floor is yours. Feel free to start.
Thank you, Bruno. Can you confirm that you hear me well?
Yes.
Okay, thank you. And I will share in a moment my presentation. Okay, so hello everyone again. Thank you so much for being here today. And as I'm the final speaker of this panel, I'm going to present the Romanians' proposal of a model for a child-friendly court. Our model has concentrated on the individual assessment of both children with psychosocial and intellectual disabilities that have been victims or accused of committing a crime in a criminal matter. I think what is important to mention at this moment is that here at Center for Legal Resources, we've conducted since 2003 working in we've done monitoring visits in centers for children that have disabilities, so institution centers, and residential facilities, where we found many cases of abuses and non-respect of human rights. So this experience that we've gained through years helped us develop what we call today a model of child-friendly justice. For the beginning, I have to say that those children who are diagnosticated with psychosocial and intellectual disabilities, so that are part of children with enhanced vulnerabilities, are one of the most vulnerable categories of participants in the criminal process, whether they are victims or accused suspects. There were many preconceptions around these categories, and we've often found that undue formalism of procedures have been combined with a lack of knowledge or expertise by the professionals that have to deal with them, so policemen, prosecutors, judge, which often results in decisions that fail to reach the child's best interest. In the previous part of the project, where we analyzed the national findings, we concentrated on the promising practices. So like my other colleagues mentioned, Nadia and Giuseppe, we also have those special hearing rooms where the children is only with one psychologist or a member from the General Directorate of Child Protection. And on the other side, there is a window that allows the prosecutors or the people who are interested to see and assess the child's behavior. But unfortunately, that is not enough, because during our findings, we found out there are almost no legal adjustments for those children with disabilities. And their assessment often does not differ from the general assessment of a victim. So for the children that have been accused of committing a crime, if they are under 14 age, there is no individual assessment carried out, and it's only carried out for those who are above 14 and that have already gone to the court stage. So it's very late to conduct an assessment at that moment, and it can have bad consequences on the development of the children. As you can see, our focus group is on children with intellectual and psychosocial disabilities. And we have to mention that sometimes when conducting a trial for the children that have been accused of committing a crime, the situation is very worse, as often police and prosecutors discriminate them and choose to pose the placement of the children with intellectual disabilities in detention or educational centers, which are facilitates that deprive the children of their liberty. So sometimes, even if the measure is adapted to the crime that has been done, it's not adapted to the children's situation, vulnerable situation, and it results in an aggravation in the child's situation, because in those type of centers, there are no special activities or therapies that are adapted to children with enhanced disabilities. So to avoid such inequalities, we at CLR have elaborated a model of individual assessment and evaluation, especially designed for children with intellectual and psychosocial disability. The model starts from a general point, which assesses the need of children starting from his disability, not from its quality, that being a victim or accused. And after that, if it is further needed, there is going to be a second part of the assessment that will evaluate the victim or the accused further needs. As a child participation is very important for us, we took 2 special interviews that help us facilitate access to adapted procedures. One is with a child victim, a young adult that just turned 18, so he was not an adult at the moment of the interview, which we'll call Mr. B for his protection, and an accused child that is placed in a state orphanage, Mr. A, now 16, and at the moment of when the crime was done, he was 14, and the crime was pickpocketing, and it hasn't been assessed, but only interviewed by the police. And you can find in our national findings a cruel interview about his sad story, that beating and the police made him say things that hadn't happened. So at this moment, I take the opportunity to thank Lily Kovac, a psychologist specialized in child behavior and a PECS consultant that helped us for more than 10 years now in cases of children that were victims of crime and other civil matters with children. And she did that once again for the case of Mr. B. Long story short, we have known Mr. B for 3 years now. When he was a minor at that time, his mother contacted us to help her in a civil case that was about his institutionalization. He was going to he was taken by the state, and the state wanted to place him definitely in a state care center. So we helped her mother avoid the institutionalization. And another important thing is to mention that Mr. B is diagnosticated with Asperger's syndrome. So nowadays, a few months ago, we were called by a police officer to be asked if the boy will be able to give a statement as the victim. The police had seen that we have interacted with the child before. And the police asked that because she think that she saw that B had a disability, and she thought maybe he would be better be put under guardianship, or maybe someone else just has to deal the assessment, because the policemen, they cannot understand him, they cannot speak to him. So at that point, we contacted Lily, who already knew him, and the police also agreed that the psychologist could facilitate the communication between authorities and the victim. So I give the floor to Lily Kovac to tell you more about the case and the communication with the police force.
Hello. My camera is disabled. It tells me that the host has disabled it, so I cannot, okay. Can you hear me?
Yes, it's working.
Okay. Hi, my name is Lily Kovac, and I'm a psychologist in child development and behavioral interventionist. And I've been working for over 20 years in government care centers for children and adults with disabilities. And I'm just gonna give you shortly my story in assisting Mr. B with the police officer. As one of my colleagues said, he's a young man now. He's not a minor anymore. And I was very surprised. It was an unexpected, pleasant surprise to be contacted by a police investigator to represent Mr. B. Our client is diagnosed, like as also Juana said, with high functioning autism, Asperger's syndrome, that lives with his mother that also has some psychological needs. Our client was very fearful. Did it pause for a second?
Yes, 2 seconds. If you don't mind, repeat what you said in the previous sentence.
Yes. So our client was very fearful of the law officer refusing to present himself to the police station. He was very anxious about his life. He was afraid that he will not leave the police office if he goes there by himself. It was a problem of altercation between him and some neighbors, misinterpretation of actions and words. And I was able to mediate and assist and translate some of our client's thought and feeling from his perspective. It was obviously that the police officer would not understand many of his words reproduction, and he was not able in language, with verbal language, to represent the series of facts. So it took some time for me with him to sit down and write on a paper, step by step, what happened, who said what, why did he said. And in some cases, he even misinterpreted the police officer, and When police officer asked questions of him, he thought, so now you think I'm guilty, right? But the police officer were not saying exactly those words, and she was not putting the blame on him. But almost everything that the police officer said, he was taking it as a blame and very personal, and thinking that, okay, so that means I'm gonna be staying here because you don't trust what I say. So I was able to translate his feelings, his perspective to the police officer, but also to translate what the police officers was saying through her words, what was the meaning of those words, because the meaning of the words were totally misunderstood by our client. So in the end, it was actually a very successful meeting and collaboration with the police officer, that actually for the first time she said that now I understand what autism means, what disability means. And this boy is actually very smart, but he cannot actually understand sometimes the meanings of my words. So that was my experience with our client B. We were going to have some mediation between our client and the neighbors, but the police officer offered actually to do that for them, and it was actually quite revealing for myself too. If you have any questions.
Thank you, Liliana. Of course, if any participants have questions, you're free to ask on the chat, or the question and answer session will just happen right after this presentation. I don't know if you wanna, in the meantime, you want to continue, Oana?
Thank you, Lily, for the brief presentation of the case. So as you can see on the screen, there is the first part of the criminal process where the offense is committed, and where the child becomes a victim by filing a complaint. He cannot personally file a complaint if it's underage. The complaint has to be filled by his parent, or it has to be filled by a prosecutor ex officio. After the complaint, an investigation occurs. So at this point, between the investigation and the hearing at the police or the prosecutor offers, a psychologist, in our view, or proposal of the model, should intervene, or a member of a multidisciplinary team that we are willing to insert in the provision, in the legislative provision, that should have a pre-discussion with the child to explain to him what is going to happen, what should we talk about at the police station, if it feels okay, by telling his or her story. And after the dialogue between the child and the policeman, facilitated by a psychologist or a member of the multidisciplinary team, occurs, the next steps of the criminal trial should happen. But as a general guidance for the next steps, if a child has been assessed once and heard once, it should not be further assessed, only when it's strictly necessary, because it gives him a sense of re-victimization, and we do not want to see that. And also, it should be offered special assistance according to the individual assessment findings. So the aim of this model is to set a minimum standard for the individual assessment of children that have been victims or accused of committing of crime. In Romania, an individual assessment is only carried out at the moment for victims, and for child when they already reach in front of the court by the probation services. But at the probation services, there is not always a specialized psychologist or a social worker. It can also be, for example, a legal professional or a total different job, but it shouldn't be like that, because the ones that are going to communicate with children with disabilities should have special training in deal with those kind of intellectual and psychosocial disabilities, which we've seen many times that were lacking at the level of our national authorities. But first of all, to briefly present our model, we should start by asking ourselves not what is a model, an individual assessment, because I can tell that everyone knows by this moment, but what should be an individual assessment for those children with intellectual and psychosocial disabilities. So we thought at s.r.l that it should be a personalized evaluation, taking specifically into account the personal vulnerable characteristic of the victim or of the child that has been accused of committing a crime, by assessing the specific needs of its disabilities. And it also should assess the type or nature of the crime, because it's a different situation when the crimes are personal crimes or crimes relating to money, crimes that happened in, for example, social care center, which in many cases the victim come from this kind of state centers because they are more vulnerable than a victim that has grown up in a family. And also it should assess the circumstances of the crime to see if the children is going to need a special adjustment for the continuing of the process. Also, another important mention is that the individual assessment should be conducting accordingly to the wishes and the close cooperation of the children. If the children does not want to say anymore or to tell parts of its story, it should be stopped at the point, because if we are going to force the children into cooperating, it's going to have worse consequences for them than leaving the statement, let's say, uncompleted. Also, our model, it can be adapted according to the nature of the crime and of degree of the harm, because there are crimes that have different intensities, and the model should have the individual assessment should have the capacity to adapt to each situation according to the disabilities, and after that to the quality of the child in the criminal process. At this moment, as we can see on the slide, the current assessment is not carried out in Romania at this point. It's only for victims, but it's not specialized for victims with disabilities. But the national legislation provides some special measures to support and protect victims, such as those adapted rooms from hearing, victims interview by a trained specialist, where is the case where they can find a trained specialist, as we presented our example with Mr. B, and all question of gender-based violences or personal crimes should be carried out by a person of the same sex as the victim. And special measures are provided for children who are always presumed to have specific protection needs, but there is no special mention of children with disabilities in our criminal code or criminal procedure code. Another important question is that who should conduct the assessment? So normally a psychologist would be the person that conducts the assessment, and where we've seen the case, the police or the prosecutor calls for a psychologist from the General Directorate of Child Protection. If they have such a specialist that has the time or he's willing to conduct and has the specialization for dealing with children with psychosocial and intellectual disabilities. But in our model, and we are approaching the multidisciplinary vision that also our colleagues talked about, the competent authority or entity may differ according to the stage of criminal proceedings, like pre-trial or trial stage, but it should be done as early as it's possible. And depending on the type of disability, and after that on the nature of crime, a different person appropriately trained may assist with communication with the victim or a child that has been accused. Let's say it can be psychologist, even a doctor that has known the child for a long time, member of the NGO organization, a social worker, maybe someone from a victim support services, etc. But this person should collaborate together with other specialists that can and with the police officers, and to ask the question if the police or the prosecutor still need to ensure that appropriate information need to be gathered for the assessment, and in the end it should propose an appropriate measure, a special measure that needs to be taken during the criminal process to further to assess if there is any risk going to be posed to the victim. The purpose of the assessment is also to identify special protection needs and to determine whether and to what extent the victim would benefit from these special measures. That would be cases that only general assessment needs to be done and not only special measures that I know, like the child should be taken from the family to a special placement center. That could be that could worsen the children's situation. So specific protection needs of the child need to be that relate to its vulnerability, needs to stop any chances of secondary and repeat victimization, to intimidation or retaliation. In this sense, we've designed a two-part questionnaire. The first part is to capture information about the child personal characteristic, the personal vulnerability, including disability assessment, with the focus on that, intellectual and psychosocial.
Oana, 1 minute.
Okay, I'm going to finish. And you can see on the left side the draft of the question, the model of questioning. And also the question should say about the risk and fear of harm. So it should identify special protection needs of the children. And the second part is a more detailed assessment to determine the level of risks faced by the children. For children that were accused of committing a crime should focus on the measure that should be taken even after the trial period. So after the court ends and the hearing ends. You can see there are some guidances, and the professionals that are going to benefit from this model are going to be trained in a psychosocial legal manner that are going to be introduced in a multidisciplinary approach of the assessment. This is the second part of the questionnaire. So in a few words, the model of model of individual assessment should be disability centered with a focus on intellectual and psychosocial. It should be in pair with a training for professionals that are going to collaborate as a multidisciplinary team, but only one is going to do effectively the assessment. And as for legislative changes that are going to be needed in order to ensure full child participation, we've thought of an introduction of an interpreter, not the one that interprets the language that is already provided in the criminal code, but this interpreter shall be both the person that best interprets the will and preferences of the child, which is taken from the CRPD, and the one that will ensure that the best interests of child is respected. Thank you. And I think there are going to be some questions on the screen, right, Bruno?
Right, exactly. Thank you so much, Oana. Very comprehensive presentation, and this is really interesting to see the questionnaire, which is a work in progress, but should already give us a glimpse to where the Romanian model is going. Take into consideration the specific situation of children with intellectual psychosocial disabilities. Like for previous speakers, you can already see the poll available with 3 questions that should help guide both the development of the Romanian model, but also all the other 2 models that were presented so far. again, if you weren't present when it was explained, the answers to this poll are anonymous. They're only single choice, and they're not exactly right or wrong answers. So we're just mostly curious just to understand from your view, also based on what you heard throughout the conference, which answer do you think would be best given these circumstances? We'll have 2 minutes. In the meantime, if you have any particular questions, I know Stephen already asked one, but we can potentially just leave that for the question and answer session. Although I was curious, Oana, as I was hearing you, seem to be saying that for individual assessment involved children with intellectual or psychosocial disabilities, there would be a need for specialized training, potentially a training that psychologists tend to have. Do you think a social worker could also have a role in actually performing the assessment, of actually doing it, or should be just a psychologist or some other specialization that's typical of psychologists? What do you think?
I think social workers could have an essential role in the child participation, as they are the persons that can say they should go into a field and to have previous known of the child situation, if it comes from a family and from a vulnerable family, if it's has a disability certificate, they are going to do that social inquiry for the General Directorate office. And so I think they are social workers that know the children before the crime, before the time of the crime, and could, if they get the proper training in the psychosocial matters, like how to they are going to learn how to assess the children with disabilities. Yes, they can do also the individual assessment of the children. And I want to make a slight mention at the third question. For the last answer, we didn't want to say to make the children collaborate, but to promote the effective participation of the children in criminal proceedings, and that has been a slight mistake from us. Sorry.
Sure, that's fine. I don't know if you'd like to comment or say anything about the other first two questions as well.
Okay, 30 more seconds for the pool.
Thank you, Stefano. Yeah, so just to read out, the first question is, what values should have the future model of individual assessment for judicial authorities? So should it be viewed as an informative instrument, so not legally binding? Should it be legal binding for the judge or prosecutor when establishing a measure? Or should the value attached to individual assessment should be according to each case, depending on the disability or the quality of the children concerned, so considering their status? The second question is, who should collect, analyze, and publish information about individual assessment at the country level? So should it be each local child protection directorate? Should it be the special department for the multidisciplinary team at the General Police Inspectorate? Or should it be the Ministry of Justice, should be in charge of collecting, analyzing, publishing information at country level related to individual assessment? And the third one, what should the most important objective of the individual assessment? Should it be to provide psychological support for the victim or accused? Should it be to recognize his or her need of protection and prepare an action plan? Should it be to prevent a secondary or even repeated victimization? Or as Owen explained, should it be used to promote effective participation of the child in future stages of the proceedings? Thanks so much for your answers. What do you think, Owana?
Yeah, I think for the first question, I would have chosen the same, because individual assessment cannot, as let's say a probation material, cannot have a standard value, and it should different from case to case. Like in some cases, it should have a higher value than on another probe. And for the second question, I think that it could be a multidisciplinary team, because there are different specialization, and they are, yeah, like I saw Stephen's question, sometimes they are going to overlap, and if it's one member from each of those three, let's say, departments, they are going to put together their experience, their trainings, and they are going to adapt as the time goes on, the assessment accordingly to the child's needs when they have disabilities. And for the last question, I would say that all those four answers have kind of like equal, should have equal importance, because the objective of the individual assessment is also to prevent the repeat victimization, but to make the children feel protected and to feel comfortable with the criminal trial, to help him overcome the negative consequences of a criminal process, and to ensure that his words are taken for granted, and that he's heard and listened and is going to be okay in the end.
Definitely. Thank you so much, Owana. There's definitely a lot of aspects to consider, especially when the victim or suspected or accused of committing a crime is a child with intellectual psychosocial disabilities. I think it was obvious from the answers from participants that it might be difficult to choose what would be the best solution, especially since that there are many overlapping objectives, but seem to be going the right direction. So then I guess at this point, I'll open this session for questions and answers. Any comments and questions you might have to the speakers, especially related to the models. It could even be more comments or suggestions. In the meantime, can start with the question asked by Stephen. So which Liliana, or I think it's either for Liliana or Owana, whoever would like to answer. So Stephen mentions that Liliana's case study shows a very positive practice. So wondering what recommendations you have to systematize access to speech and language therapists, or even specialist psychologists in the individual assessment process. Because it seems like in the case of the child, Mr. B, sounds like he was lucky, but how to make sure this actually becomes a systematized practice. Would you like to take this question, Liliana? So she's still, I think Liliana is with us anymore, but would you like to take
I don't see her online. I don't see her online at this moment. So
go ahead, Owana.
Yeah, unfortunately, Liliana had to leave us because she's dealing with another case now. But I think that we can systematize access to interpreters or speech and language therapists by forming multidisciplinary teams of therapists, and by changing the harsh legislative provision that cannot be adapted at this moment, because they are, well, let's say they are old-fashioned, and they are still dealing with the disabilities as a medical model, not with the social model, but if all together, like the psychologists, social workers, judges or magistrates came together with also children and parents that are the ones that know better their situation, there should be step-by-step systematization of the language and speech therapists.
Okay, sounds like you're advocating for also multi-agency, multidisciplinary approach involving not only the child, but also the caregivers of the child. And in the individual assessment itself, do you think, well, you already mentioned that social workers could also be involved in doing the individual assessments, but do you see anyone else just being helpful during the moment of actually individual assessment is performed?
Well, it depends on the children's situation. Like if he came from residential facilities, one of, let's say, center chief or the one medical assistant that knows better the children and can communicate easily with him or her can facilitate access to the individual assessment. But as I mentioned, she should receive specialized training for because maybe he knows how to deal with a disability, with a person with disability, but he cannot understand what the legal provisions are or what the individual assessment is going to be useful for. So we were thinking that maybe from the children that are already in the residential facilities, there can be like individual assessment done when they are admitted. If it is going to be ever needed. We hope not, because we don't want any more victims or children that are accused, but it can also, if by doing this prior assessment to the institutionalization, we can have a view, a glance at what is going to be, how the children is going to assess in the criminal trial, if it's ever the case.
Great, thank you, Anna. Don't know if any attendees have particular questions they'd like to ask speakers. I know I have several, but I don't want to take the floor completely. So in the meantime, I guess I can just ask mine, because I was very interested, especially I was hearing Oana and the particular model, individual assessment, especially taking into consideration the types of crime. So my question is actually for the three speakers. So I understand even the Victims' Rights Directive mentions that individual assessment should be conducted, especially when specific crimes are committed, such as gender-based violence. And my question is, do you think individual assessment should be conducted, should be a standardized process that should be applied to all types of crimes, not only serious crimes explicitly mentioned in the Victims' Rights Directive, such as human trafficking or gender-based violence? What do you think? I don't know who'd like to go first. Not, I could just suggest someone.
I can start.
Go ahead.
Because, yeah, I think that we can look to the directive as a minimum standard. And of course, our idea about the individual assessment is that to have something that is the minimum that is standardized for all the procedures. And in your question, for all the crimes should affect, but also to have some additional question that can be relevant to different circumstances that can be applicable in different cases, because in a law you cannot put the whole life with it, with all its details. So yes, I think we should introduce it not in only the crimes that are mentioned within the directives, but always to keep the idea that this is the minimum and we have to add some additional points that are in accordance to the particular case.
Interesting. Thank you, Nadia. What do you think, Giuseppe?
I don't know if you can hear me probably, but you cannot see. Right, wait a second. Yes, well, I just followed the answer that Nadia already gave, and it's interesting. Definitely, the safeguards from the directive have to be in place, I guess, and we need to work and we need to be sure that those safeguards are not disappointed, let's say. So at least we know that we have to do work in order to be sure about the safeguards. But definitely individual assessment, it's something that has to be relevant also for minor crimes. And I would say every situation that can bring also prejudice to the life of a child, more in general. So I think, yes, I think in terms of implementation, we should be aligned and we should follow the line of the implementation of law. But in terms of thinking of the future and thinking which possible developments also have, thinking of individual assessment processes, it has to be developed even in other situation and minor crimes as well.
Interesting. Thank you, Giuseppe. Oana, what do you think?
I think that ideally what you said, that the assessment should assess each crime, not depending if it's minor or not, would be the final result of each individual model of individual assessment. But right now I feel that taking our country situation, we haven't fully transposed and implemented the victims directive norms in our national legislation. So we should firstly see how we can ensure that those provisions are being respected, and after time passes and the professionals are being trained and they understand how to deal with children with disabilities, sure, there can be another mention of each type of crime. We've actually kind of tried to do that by adding space where special mentions can be made by those that are going to assess. So hopefully it's going to work.
I hope so as well, Oana. Thank you so much. I don't know if anyone has any other questions. We're almost at the end of this conference. Thank you so much for our speakers and the wonderful presentations and the insights, and also the participation of the audience. I mean, we're definitely going to planning to use all the information and your views as a helpful guide as we're continuing our work and developing our models of individual assessment to achieve a child-friendly justice reform. And hopefully then we can answer the question whether justice can really become child-friendly. That's what we hope to achieve in this project. If there are no questions, then I'll give the floor to Antinea to wrap up.
Thank you, Bruno. And yes, actually, we are going towards the end of this conference, but even I would say also to new beginnings. Based on all the inputs and the information that were given to the audience about the models, we would kindly invite the audience to even share with us via email or to contact us even in another phase. Just to even share thoughts, comments, opinion would be really great, just to really be impactful with all the tools that we are collecting or developing under this project, and even who knows in other within other contexts. I would like to really thanks on behalf of Prism. Well, first of all the staff team who contributed to the realization of the conference, all the panelists that brought a great contribution to this conference, the technicians that were assisting also for the preparation and during the conference, for all what was needed for this successful events, the interpreters for the great work that I've been doing during the 2 days. It was really impressive. And really, like all the institutions, the local NGOs, the human rights organizations that have been attending on behalf of their, in some cases, participants or members been attending the conference. This conference was an opportunity to exchange knowledge, but also experiences among professionals from different EU countries, to learn from other legal systems what works well and what can be improved, to reflect on what to strengthen and what to change. The adoption of a multidisciplinary approach in the criminal justice system towards children with enhanced vulnerability, we've seen different specific types of vulnerabilities, is a key aspect highlighted under the EU legislations and already transposed in part in Italy. Well, with a less like national intervention in our partner countries, it allows to take, that's why it's really brilliant, the work that our partners are bringing, even in terms of advocating their systems. It allows to take into consideration all the children's needs from the perspective of an interdisciplinary teamwork of professionals with a legal and social background, both needed, as we've seen during these 2 days, for an effective protection of children's needs. Last but not least, we'd like to invite to stay updated about the next activity of the project, as the project will be running for till next summer, and to stay in touch with us. Just ending up this conference, we also would like to invite you to think about some specific questions. But we would like to give you some questions as an input for reflection, even once you will leave the Zoom platform. One of these questions is, which features shall a model for inter-assessment have? Another question is, how important is ensuring a multidisciplinary approach for the justice system? And the third one is, are unaccompanied migrant children receiving the same treatment as local children when involved in criminal proceedings? Well, these are questions that actually were already covered by some panelists, and there is still space for further reflection. And we are really delighted of the participation of the audience and the patients, even for the little delays and changes we had compared to the initial agenda. So thank you so much, and we hope to stay in touch with you. Thank you. Remember to fill up the evaluation form, just as a reminder, for the today's session, and for those who also were with us yesterday, even for yesterday. Thank you. Thank you.